morning, colleagues, members at M46 here and on the virtual platform. Let me also welcome members of the public with us in their various platforms, members of the media and our support team. Good morning on this day, the 17th of October. Today we have a committee meeting whose purpose is for the chair to make the long-awaited response to the application that would have been presented here on the 21st of September. So we're convening today for that purpose. Maybe before I proceed, just to check with Serpo if there are any apologies. There seems to be an echo. Don't know where it's coming from. Do you have any apologies?
Thank you, Chairperson, and good morning to everyone. No, there aren't any apologies that I'm aware of. Thank you, Chairperson.
Thank you very much. As I proceed, just before I start, I see a hand that would have been there even before I started the meeting. I recognize Honorable Olamisa.
Thank you, Chairperson. Thank you, colleagues. We did receive a legal opinion as it was requested yesterday. Because of the sensitivity of the issue of fairness, when the recusal application came, the UDM made only one recommendation for the committee to obtain an independent opinion from outside counsel. However, we have made inquiries from our attorneys in the PP cases. And to our shock, they informed us that Ismail Jami, a senior counsel who has gave us this opinion, is currently representing the DA in the Zuma parole matter, which is, sorry, which is pending before the SCA, and may also go the concourt irrespective of the outcome.
Recording in progress.
We do not comment on the integrity of Jami SC, but his appointment to this brief is clearly problematic because it is tainted by a conflict of interest at two major levels. One, the DA is the complainant in the impeachment motion, which gave rise to the inquiry in the first place. Two, the recusal application involves honorable member of the DA. Jami SC should not have been appointed by the committee. He also should have not accepted the brief. How can the public protector and members of the public believe that she could get an objective and independent opinion from somebody who is currently representing the DA in a high court, rather high profile matter? Finally, we are also informed that this senior counsel has also previously represented the DA when it was firing Patricia de Lille as mayor of Cape Town. We are still investigating other less prominent cases in which he may have been regularly briefing by the DA. The UDM, therefore, demands that a truly independent opinion be obtained We also need to be given time to consult our own legal experts before we can be implicated in illegality. This is not just a matter of voting numbers where the ANC and DA can bulldoze the committee with numbers. So we reject this opinion in total. Thank you.
Thank you. Thank you, Honorable Alomisa. I had indicated that today's meeting has a very focused and a single purpose to bring back to you issues post our 23rd September meeting. And the very first and the main point of today's meeting is the chairperson presenting and responding to all of the issues that would have been raised in the recusal application. We will later on deal with other matters that would have arisen once I conclude the response of the recusal. I did not want to rule you out of order. I allowed you to proceed and conclude. And I note what you're saying. We'll deal with that later in the form of a response. For now, honorable members, I want to take this opportunity, as I promised on the 21st of September, immediately after Advocate Mpofu would have presented the recusal application, that we welcomed that application and that we're ready and will do everything else to respond comprehensively to that application. And I would have indicated that I would focus on the facts of this process and that we will respond in detail to that. Today is convened specifically for that purpose to be done. I want to start, honorable members, in welcoming you that following the recent application for recusal lodged on the 20th of September 2022 on behalf of the public protector, an oral representation made by Advocate Mpofu on the 21st of September 2022, seeking a recusal of myself and honorable member Mr. K Mileham from the committee established in terms of section 194 of the Constitution, and a committee meeting held.
Honorable Chair.
Yes,
Do we have the
Honorable
document? Yes. Do we have the document that you are reading? Is it sent to us or it's only with you?
It should have been sent to you. Just check your emails. Thank you.
No, Chair. What I have is the legal opinion. And actually, I wanted to come after Honorable Holomisa to say that, and you've just captured it correctly, Chair, that in the meeting of September, the last meeting we had, we never as a committee gave you a mandate to go seek legal opinion. After Advocate Mpofu presented the issue, we sat as the committee and we gave our views and we asked you to recuse yourself, directly yourself. We never ever have a resolution as a committee that says that you must go seek legal opinion. That's one. So if you are reading this legal opinion that was sent last night, which we reject, by the way, it's very wrong, Chair. And we want to utter the same sentiments as Honorable Holomisa, that you went to seek the legal opinion from the same person who is the DA lawyer in all the matters that at least we know of.
I have responded to that and made
No,
a ruling on that matter, Honorable Mautwe.
You have not responded.
Honorable Mautwe, I've
With the
responded
greatest
to that
respect, Chair.
and made a ruling. Please do not repeat that. Honorable Zungula.
Chair, you have not responded. Okay, I'll give Honorable Zungula a chance, but I'll come back.
I am giving Honorable Zungula their platform, not you. Honorable Zungula.
And your body language is a problem, Chair. You know, when we speak here, we can see through your body language already what we are going to say. We are looking at you when Honorable Holomisa was speaking. It's very wrong. You should be the chair that is
Honorable
unbiased.
Zungula, you are on the platform.
Thank you, Chair. Greetings to the colleagues, the public, and everyone that has joined. Mine, Chair, is to ask two things. The first one is that normally when there's a meeting, there ought to be an agenda that is for any particular meeting. That agenda gets to be adopted, rejected, then we know what the meeting is all about. And it becomes a meeting of the committee because the committee would have adopted whatever that will be discussed. I don't recall you doing that this morning. That's the first thing. The second thing is that the emails that you are saying were sent is only the notice of the meeting that is today, and also the legal opinion. This recusal response that you are reading from was not there, is not there. So I want to ask, Chair, are you intending on sharing with us so that we are able to read, to understand, so that when we deliberate after you are done speaking, we are able to make informed, positions on your response? Those were the two things, Chair. The first one is a meeting as an agenda that gets to be adopted. The second thing is that your response, share it with us. In fact, yeah, share it with us, Chair. Thank you.
Thank you, Honorable Zungula. Your first point has been attended to. The purpose of this meeting would have been explained properly. I would not repeat that. Secondly, what I'm now tabling has been sent to all of you. And I'm going to ask members. I'm very patient. Today has a particular purpose, and nothing is going to derail us from doing that. I want to proceed and respond to the recusal application. I'm going to ask that members don't raise any frivolous points and allow the chairperson to proceed with presenting the response to the recusal application.
Chair, you are not going to do that, ne? You're not going to treat us like that, please.
So sorry,
No,
you have not raised your hand.
Like that. You are not going to treat us
you have
like
not
that.
raised your hand, Honorable Malema.
No, I'm raising my hand, but you are not going to. People have raised concerns here. Firstly, you have been asked if
Honorable
that document
Malema,
you are reading.
Honorable Malema, you raise your hand, recognize and speak.
Chair,
Not
my
in a
hand has
way.
been up.
I still don't see it, but I'm going to allow you to speak.
I can see it, Chair.
Chair. Points have been raised here. You have no mandate to do what you are doing. To come here and read something that we didn't mandate you to go and do, and then read it to us as if we are your audience, that we came here to listen to you. You are reading an opinion that was not sourced by anyone. This committee has got no minutes of such a thing. Secondly, you convene a meeting and you come and tell us that today we're going to do one thing only, and this is what we're going to do. And then you don't seek for adoption of that which you are suggesting is today's agenda, if that is the agenda. You even informally just go like, hey, is there apologies? As if we are some kids who are here to come and listen to you running all over us. You're not going to do that. You have no mandate to do what you are doing, and you know that very well. And we reject this report that we have never asked for, with all the reasons advanced by the speakers before me. So I don't understand what is the purpose of this meeting. You call a meeting to come and speak on a mandate that you gave yourself. Why can't you go and address yourself instead of coming to address us here on something we never requested from you? This is out of order, Chair. We don't agree with that approach.
Thank you. Honorable Malema, you have raised the same issues that were raised by Honorable Olomisa, Honorable Mautwe, Honorable Zungula, and I have responded to all four of you about the purpose of today's meeting. And when we concluded the 23rd of September meeting, we indicated, in fact, we said in 2 weeks' time we would have come back and convene this meeting for only one purpose. And that purpose is the response of the chairperson to the recusal application. There is nothing unclear about that. It was raised and firmly agreed to on the 23rd of September. You would have received correspondence inviting you to this meeting with that purpose in mind. So I've made a ruling that all four of you, the points you have raised are not sustained, and I would like to proceed with this meeting for the purpose that it was planned for. Thank you.
Chairperson,
With that, colleagues,
Chairperson,
On a point of order, sir.
Honorable Dlakode.
Chairperson,
Thank you very much, Honorable Chairperson. Good morning to you and our colleagues. Honorable Chairperson, I agree with you. On that day when we discussed the issue of recusal, then we agreed that after 2 weeks we'll convene where you will be responding. I want to plead with my colleagues that let's allow the chairperson to respond. Then we will raise our concerns after the meeting. He has a right to respond to that application for recusal. So can we please allow him to finish what he's presenting so that we can discuss it after? Thank you very much.
Thank you, Honorable Dlakode. That will always be the opportunity for members to engage with the response. I now proceed, colleagues.
Chair,
Chairperson.
our hands are up. Please check your gadget. There's few hands. Honorable Zungula was first, I was the second. Please recognize us.
All of those hands did not go down. They've always been up. So these are legacy hands that you have.
No. My hand
No,
is.
my hand just went up fresh now.
my hand just went up just now, Chairperson.
I did the same.
Are those the point of order so that I've made a ruling on this point? I am hoping it's for a different point. Honorable Mautwe.
No, Chair. Once again, we want to remind you, and I'm happy because you started with it by saying, after the meeting of September, you said you'll come back to us in 2 weeks. You never said you are going to seek legal opinion. Honorable Dlakode just also confirmed that the proceedings of the meeting of September agreed that you will come back to us in 2 weeks. The issue of you seeking legal opinion, Chair, it is what we have a problem with. And now you are even reading that legal opinion that is prepared by a DA lawyer. It's wrong, Chairperson. That's what we are saying, that we can't continue with this meeting. But now what happened to the OR Tambo organization? Why are you handing over power to the DA like that, Chairperson?
Thank you,
It can't be
Honorable
correct.
Mautwe.
You must be condemned for this, Chair.
Thank you,
You are
Honorable
giving back
Mautwe.
the power to the DA. You don't have that power.
Thank you, Honorable Mautwe. I've made a ruling on the points you've raised. I'm not going to repeat and allow you again to repeat the same points. Honorable Zungula.
Chairperson, my first issue is the issue of the agenda or the program of the meeting being
You
adopted.
have raised that, Honorable Zungula, and I've responded and made a
Chairperson,
ruling on the matter.
Allow me to finish, Chairperson.
Don't
Now,
repeat the same points.
Allow me to finish. Don't interrupt when I'm speaking, Chairperson. Thank you. Now, the speakers are saying in the last meeting, the agreement was that we are going to come to this particular meeting to hear your response. Now, on the proposed agenda for today, because it's still a proposed agenda, the committee has not adopted this agenda that you are saying, we must proceed with it. It includes an overview of an independent legal opinion, which was not sanctioned by the committee. That is why, Chair, I'm appealing to you. Let us first start with the basics of calling the meeting. The basics is that in a meeting, there is an agenda that must be adopted. We can't allow you to proceed, Chairperson, and then later on, when you come to the part of the independent legal opinion, so-called independent legal opinion, when we raise our issues, you say the meeting adopted or the meeting was agreed that we are going to proceed with the meeting with that particular agenda. Let us first deal with what is the purpose of this meeting, and we remove things that are not supposed to be part of the purpose of the meeting. We deal with your response as the last meeting indicated that that will be the purpose of this meeting. Ezinye nezinye izinto, Chairperson, that were not agreed to, that we've not adopted today, they must be removed from the agenda. Thank you.
Thank you, Honorable Zungula. Same point. I've made a ruling. Honorable Lothrit.
Good morning, Chair and colleagues. Thank you very much. I want to concur with Honorable Blakude that at that meeting in September, that was what was agreed to by the members who were actually present on the day. And the question about the agenda, yes, you have ruled on that. But I think we also have to understand that this was the instruction and decision from that committee on that particular day. And therefore that is the agenda, and your response is the way that you would like to respond, Chairperson. And if it means that you have a legal opinion as your response, then that is the agenda point that we are busy. So there's nothing that needs to be removed. You are in fact now dealing with the matter as decided by the committee at the last meeting. Thank you.
Thank you, Honorable Lothrit. That helps to further clarify the point. This is the agenda that would have been sent to all members. You are invited to this meeting on the basis of what you see there on the board. It's very clear. There's no confusion about that, unless there's something else we're looking for. And for that, colleagues, I insist, I want to proceed. I've attended and listened to all of the issues you've raised. They are not relevant to the matter that we're dealing with, because that confusion has been clarified. The last meeting of the 23rd was very clear about the committee taking a decision to seek legal opinion. That's a decision of the committee, and I'll come to that later once I've finished with my response. So I'm asking members not to repeat the unnecessary points of orders when matters in front of you are so clear. I therefore proceed. Honorable Olomisa, is that the legacy hand?
Thank you very much, Chairperson. Please be patient with us. Can we start with the item number 3, if I'm not mistaken, which talks about legal opinion, and read that legal opinion with what we have raised? Because surely that legal opinion, if we have read it properly, it comes from somebody who is questionable insofar as the conflict of interest. You seem to want to dodge this issue. Let's start with that. We will get your response. Don't worry.
Thank you, Honorable Olomisa. Thank you, Honorable Olomisa. I heard you. You've repeated your very first point you've made. I'm now proceeding with the meeting in the way this agenda has been laid out and sent to all of you. And I ask you to please desist from making these unnecessary points of intervention when matters have been clarified not once. And I'm
Mr.
asking that you don't do that again. I want to proceed, members. Taking the facts into account and having taken time to carefully consider the PP's application, I have decided not to recuse myself. I repeat, I have decided not to recuse myself. I do so in the belief that the PP has failed to establish any grounds upon which it can be said that I'm biased or that any of my conduct may give rise to an appreciation of bias. I'm satisfied for the reasons set out below that there is no basis for me to stop discharging the important public function with which I've been charged. I remain open-minded in my conduct of the proceedings and can say with certainty that I've not reached any firm conclusions in relation to any of the content of the motion. I have no preconceived notions as to the outcome of the committee's work. Indeed, I have emphasized that this must be the position adopted by all members until the conclusion of the hearings. I've listened to the evidence and I'm acutely aware that the PP has not as yet led to evidence as has been indicated she intends doing, and has not yet had the opportunity to provide her oral evidence. Nor has the PP, save for a handful of questions, answered members' questions as yet. There can be no doubt that the committee's process must be fair, or that standard has been met. The PP has been aware of the contents of the motion for a significant period of time. Prior to the commencement of the hearings, the PP was afforded the opportunity to make written representation to the committee, but declined to do so. In addition, the PP has an opportunity to deal with the written and oral evidence presented by the evidence leaders, may lead her own evidence, and respond to questions from members and the evidence leaders, and will, at the end of the hearings, be afforded another opportunity to make representations to the committee in relation to any findings or recommendations prior to such being adopted by the committee. She has at all times had the benefit of her legal team's assistance and will continue to do so. I now attend to paragraph 4, 14, 16, 18, and 19. The recusal application is considered in the light of the written and oral submissions made on behalf of the PP. Whilst I undertook to provide the committee with a detailed paragraph by paragraph response to the application, this has not always been possible because the application mostly appears to be generalized and non-specific, with little or no elaboration in the oral argument. Where the application has sufficient detail, I have endeavored to deal with it and to address the context in which the conduct complained of occurred. As a chairperson, I have had to ensure that I maintain order in the hearings. I do not draw a comparison with a court where much of what has occurred would not have been permitted, because the committee is not a court and I'm not a judge. I also made it clear early in the proceedings that the members would not be curtailed in the questions they ask, and that in the final analysis, should any of the questions asked and or responses given be irrelevant to the motion, then it simply meant that the committee would disregard them when preparing its report. This remains a unique process. However, it cannot be forgotten that this is essentially an oversight process, and as members who are constitutionally bound to hold the PP to account. With reference to the alleged warnings said to have been repeatedly issued, I do not regard remarks by Advocate Mpofu SC to be warnings, and instead applied myself to chairing the proceedings without any fear or favor and in the best interest of the inquiry. I recognize that I needed to ensure, to the best of my ability, that the process continues and that it not be allowed to be sidetracked or derailed. So where such comments were made, I did not respond in a similar vein, because it was not in the best interest of the work of the committee to challenge Advocate Mpofu on every single comment made. I did not do so. If I had sought to do so, I would have had to make public rulings, specific rulings on each comment, which would have given rise to a plethora of objections, with the process and questioning of witnesses, in particular, being constantly and inevitably interrupted and delayed. My priority was and remains to ensure the orderly conduct of the proceedings, that it would not further or progress the work of the committee to engage Advocate Mpofu by taking issue with every statement or interjection uttered. The rules require that the process be completed within a reasonable time frame, and the Constitution requires that all constitutional functions be performed diligently and without delay. The vague references in the recusal application to a worsening situation ostensibly aggravated by the conduct of the chairperson are not borne out by the facts and are denied. However, at all times, it has been my intent that once the evident leaders have completed the leading of oral evidence, I would place on record my position in relation to the litany of accusations, threats, comments, and what have now been referred to as warnings. I discussed this approach with the legal services advisor, Ms. Fatima Ibrahim. Indeed, the relationship with Advocate Mpofu SC, the PP, and the remainder of the legal team through the proceedings remained, in my view, cordial and professional. With particular reference to the issue of relevance of the evidence of witnesses, when objections were raised and I was satisfied with the explanation provided by the evidence leaders as to why such witness was being led, I allowed the evidence to continue. Conversely, I've made rulings regarding relevance which were in favor of the PP in circumstances where the evidence leaders or even members have questioned particular lines of questioning pursued by Advocate Mpofu on behalf of the PP. In paragraph 5, when complaints were raised in respect of the participation of Mr. Mileham, legal advice dated 20th July 2022 was obtained from the chief legal advisor, who inter alia advised that Mr. Mileham's marriage to Ms. Mazoni did not, in and of itself, preclude him being a member of any parliamentary committee. This was accepted by the committee and no further objection was raised by any member. The motion was lodged by Ms. Mazoni in her capacity as the chief whip of the Democratic Alliance. Mr. Mileham, as confirmed in the legal advice received, is entitled to occupy his position as a member of parliament and participate in committees to which he is appointed. On the basis of the above mentioned advice, no steps were taken for his removal from the committee. There is in any event, no assembly rule that empowers me as a chairperson to permanently remove any member from this committee. To now impute a failure to exercise a power I did not have to constitute a basis for recusal on my part is without any merit. I do recall that there were instances where I both allowed and disallowed points raised by Mr. Mileham, as was the case with some other members of the committee. As a matter of principle, it does not behove any legal practitioner to threaten or issue warning to a presiding officer. At all times, I've endeavored to keep order in the meeting. For various reasons, it remains a constant challenge to ensure that those who have the floor are permitted to speak uninterrupted and without interjections. This task is made harder by the fact that the committee is so large. And as chairperson, I must ensure that all role players are afforded the opportunity to participate meaningfully. There has been no worsening or deterioration of any alleged situation, nor have the conditions become intolerable or impossible for the inquiry to continue. I deny that the standards of fairness, reasonableness, and transparency have been breached. I accommodated Advocate Mpofu SC in numerous respects, in respect of affording him more time in cross-examining witnesses, in a manner in which he conducted his cross-examination, and being permitted to raise whatever objections he sought to make, and placing matters, I quote, on record, The accusation of a lack of transparency appears to relate to an allegation of collusion with evidence leaders, which they have already dealt with during their oral address and to which I refer below. To the extent that there have been rulings made during the proceedings, these occurred in circumstances predominantly where Advocate Mpofu has refused to heed the ruling of the chairperson, to allow other persons who were speaking to complete what they were saying, and where he sought to interject without leave. These efforts to maintain order in the meeting do not constitute unfair treatment, nor can they be construed as bias. It is my duty to maintain the order and the decorum of the proceedings, and will continue to do so. Let me attend to the first ground, the scope of the inquiry. I did not act unfairly or unreasonably, or display bias or substantial prejudice, or act in a manner that gives rise to any reasonable apprehension of bias in relation to any rulings made in relation to the scope of the motion before the inquiry. Whilst Advocate Mpofu on a number of occasions raised this same objection, I indicated several times that it was the motion in its entirety that served before the committee. As chairperson, I was not entitled to narrow the scope of the motion. It is the motion that is before the committee, and not only the grounds on which the independent panel, after conducting its desktop exercise, concluded that there was prima facie evidence of misconduct and or incompetence. The independent panel was not empowered to amend the motion in any way, as is being suggested in paragraph 22. Just as the independent panel's finding that there is prima facie evidence on some of the grounds is not sufficient in and of itself to justify a finding by the committee that a particular charge has been proven, so too is the independent panel's conclusion that on some grounds there was no prima facie evidence sufficient to justify a conclusion that the committee should not have any consideration to and dismiss the charge on that basis alone. In considering whether I had the power to broaden or narrow the motion, I considered provisions of section 194 of the Constitution, the legal framework within which the committee operates, as well as the relevant decisions of the Speaker, the independent panel, and the National Assembly. This was also supported by Ms. Ibrahim, with whom this was discussed, and who advised during their discussions at the committee meeting regarding this issue on the 20th of July, 2022. The advice was to the effect that neither the chairperson nor the committee had the power to narrow the scope of what the National Assembly had referred to it on the 21st of June, 2021. Under section 1941B of the Constitution, the committee is tasked with making a finding on whether the PP has committed misconduct and or is incompetent. The committee's function under the National Assembly rules is to consider motions initiated in terms of section 194 and referred to it, and to establish the veracity of the charges and report to the National Assembly thereon. For this purpose, the committee is entitled to consider oral evidence which the independent panel was prohibited from considering in any form, further evidence adduced by Advocate Mkhwebane and or the evidence leaders at the inquiry, and evidence oral and otherwise flowing from the public participation process which parliamentary committees are obliged to embark on. The PP's complaint appears to be one of material prejudice, solely because the PP would be called upon to produce evidence to rebut charges in respect of which the independent panel has ruled that no prima facie evidence or case exists. I'm not able to deal with this claim further, factually, as the precise nature of the material prejudice was not elaborated upon by the PP. As far as I'm aware, the PP remains on full pay and her reasonable legal cost, travel and accommodations are being covered by the PPSA. Accordingly, there is no basis for this ground of complaint. Ground 2, I did not act procedurally, irrationally, unreasonably, or to the prejudice of the public protector. Under Rule 183 of the rules, the chairperson is empowered to determine directions and procedures for the committee. The directives allow for amendment from time to time, as well as for condonation for non-compliance. The facts as set out in this section of the PP's recusal application are not a correct reflection of what actually transpired. The committee's legal team proposed an addendum to two provisions of the directives. The proposed addendum was provided to the PP's legal team for comment on the 1st of September 2022. The PP objected to only one of those proposed changes and did so in a letter dated 6 September 2022, which the legal advisor was to consider and advise on. As Ms. Ibrahim informed the committee on 23rd September 2022, she received the letter in the afternoon and immediately realized that there was a miscommunication, as the letter spoke of the draft addendum as a matter that had been finalized, whereas this was not the case. She intended raising this with me at a meeting held that evening, but took ill during the meeting and was hospitalized, with the consequences that this letter was never responded to and did not receive attention prior to this application being brought. However, at all times, the draft addendum was never applied, nor was it ever adopted and issued by myself. The factual position is thus that the addendum has to date not been adopted. The directives have not been amended in accordance with the proposed addendum, and there has been no stipulation that the proposed changes must operate retrospectively. Accordingly, there is no merit to this ground as a basis to impute any bias. For the sake of completeness, I dispute that in relation to Mrs. van Lochrenberg and Pillay or Ms. Baloy, that it had been agreed that they would be recalled as indicated in paragraph 28. It was only after the completion of the cross-examination that Advocate Mpofu sought to reserve his rights to recall Mr. van Lochrenberg. The latter testified on the 13th to the 15th of July. The evidence leaders led him, and this is important, for approximately 4 hours, 20 minutes on the first day. Advocate Mpofu thereafter utilized 8 hours. The members questioned him for 1 hour, 10 minutes and did not complete their questions. The outstanding questions were posed in writing and a response was received. And you'll remember those 3 members who never were able to pose their questions directly. Mr. Pillay's testimony was subject to a 1-day restriction. He is not in South Africa, and there appears to be no indication as to when he intends returning. The evidence leaders were so informed and relayed this to Advocate Mpofu. The proceedings commenced at 9 instead of 10, as you will remember. For this reason, Mr. Pillay was examined by Advocate Bauer SC for approximately 2.5 hours, cross-examined by Advocate Mpofu SC for approximately 3.5 hours, and the members questioned him for approximately 2.5 hours. There you go with your time allocations. In relation to Ms. Baloy, Advocate Mpofu SC objected to evidence for the first 20 minutes of the day. She was led for approximately 3 hours with interruptions, and she was cross-examined for approximately 3.5 hours, almost uninterrupted by Advocate Mpofu. The members asked questions for approximately 2 hours, 15 minutes. The evidence leaders informally made contact with the witnesses or their representatives, given Advocate Mpofu's request, and requested that they voluntarily avail themselves to further oral questions from Advocate Mpofu SC in an endeavor to see whether this request to recall them could be accommodated and whether they would willingly return. They refused. The evidence leaders requested that the Secretariat formally address letters to them so that their response could be formally recorded, which has occurred. This was in an attempt to accommodate the request from Advocate Mpofu, notwithstanding that Advocate Mpofu had been afforded a reasonable time to conduct his cross-examination. The directives allow for questions to be answered in writing, The witnesses have indicated a willingness to do so under oath. The PP's legal team is not amenable to fashioning such questions, nor has there even been any indication as to the nature of the questions to be asked. I never issued the addendum, unilaterally or otherwise, and therefore never unfairly shifted the goalpost as alleged in paragraph 28 of the recusal application. Given what is stated above, there is no impediment to the PP's preparation of the witnesses she seeks to lead, and therefore no conceivable prejudice, real or perceived, that could conceivably give rise to any reasonable apprehension of bias. There are no predicaments that have been created. The committee's stance in relation to the motion does not make it impossible to lead evidence. Of course, the effect of the recusal application, as we all know now, has resulted in a delay in the completion of the evidence of Mr. Dyantyi, yet to be cross-examined, which is highly undesirable, and the leading of the evidence of Mr. van der Merwe. To date, the PP's legal team has not filed any witness statements, and it appears that to date, there are no witnesses that they seek to call and in respect of whom a summons is required, other than the president, in relation to which the committee refused the request for a summons. And on the third ground, I deal with that, issuing a subpoena to Mr. Ramaphosa. I did not act unfairly or unreasonably or show manifest bias. I make no comment at this juncture in relation to the allegation that the president had made scathing remarks against the PP. In this regard, as indicated by the evidence leaders and pursuant to the directives, the evidence leaders will be referring to the affidavits filed in court proceedings as opposed to calling witnesses, and in relation to the CR17 Bosasa aspects as indicated by the evidence leaders in oral submissions. During oral submissions, Advocate Mpofu claimed that I had blocked the subpoena out of a desire to pander to Mr. Ramaphosa and whatever largesse he can offer. The written submission suggests that I had ruled in a manner which exhibited manifest bias against the PP and in favor of Mr. Ramaphosa, based on a presumption that I'm a loyal member of the ANC. I have reiterated that I approach my task with an open mind. Loyalty or membership of a political party of which the president is a member does not automatically give rise to any perception of bias. The decision complained of was not mine. It was the committee's. And the committee acted lawfully and reasonably. Legal advice was obtained and conceded. Thus, this claim is false and made without evidence. In the committee's consideration of whether or not the president should be summoned, Mr. Herons stated that the legal opinion provided by the legal services was very helpful, and that before deciding whether the president should be called or not, the legal team for the PP or the PP itself needed to submit a substantive motivation that met the very high standard of the relevance that the legal opinion set out. He was of the view that the committee should not simply say the president's evidence was irrelevant, and that the PP had an obligation to convince the committee that the evidence that the president could give was relevant and in what respects. Mr. Heron suggested that further information was required from the PP because the letter sent lacked the specificity required by the relevant clause in the directives. The requirements of the directives are known to the PP's legal team and are clear as to what was required in seeking a summons. This request did not carry the support of the committee. I move to ground 4. Favoritism, collusion, and oppositional posture. I deny that I've shown bias or favoritism towards the evidence leaders. A degree of cooperation is required between the chairperson, the committee secretariat, the support team, and evidence leaders of the committee to function effectively. This is not unusual, unfair, or prejudicial. This cooperation is reflected in the terms of reference, clauses 4 and 6 in particular. Collusion implies something sinister, underhanded, and or unlawful, and denotes an effort to conceal what should be disclosed with an improper purpose in mind. The legal meaning was addressed by the evidence leaders in general on the 21st of September 2021. Whilst the written application for recusal makes such allegations, there is no evidence provided to sustain such conclusion, and none was specifically referred to in the oral address to which I can specifically respond. This is so because there is no evidence of collusion. Simply put, it has not occurred. All interactions that I've had with the evidence leaders have been in the proper discharge of our respective functions. The time allocated to the evidence leaders is less than the time either allocated to and or times ultimately appropriated by Advocate Mpofu, notwithstanding allocations for cross-examination of witnesses, in addition to the times given to him at his request for addressing and or placing on record numerous matters. The evidence leaders have seldom raised objections that have required a ruling. When compared with the number of times these have been raised by the PP's legal team and even the members, the evidence leaders have generally not sought to belabor the points. They have followed rulings and have seldom led evidence over set limits that required me to reprimand them. The only exception to date was the evidence of Mr. Sithole in reply, when at the outset it was made clear by evidence leaders that further questions were required arising from the cross-examination, and I afforded them the latitude. There were then numerous objections and repeated interruptions during the further questioning of Mr. Sithole, which resulted in the flow of questions constantly being interrupted, with the resultant effect that it took longer. All of this, I believe, the record will show. To the best of my recollection, I've not always ruled in favor of the evidence leaders. This too, the record will show. Paragraph 33 of the recusal application has various sub-paragraphs that detail alleged examples of bias and favoritism. They are incorrect and or unfounded, and I address each in turn. Paragraph 33.1 of the recusal application. The PP submits that I've rejected almost all objections she put forward. As only one example is provided, it is all I can meaningfully deal with. It is incorrect. Advocate Mpofu indicated in his oral address that he had raised various objections that the evidence led by the evidence leaders was irrelevant, which were rejected out of hand. The only example cited relates to the evidence of Mr. Ndou. Advocate Mpofu argued that evidence leaders sought a relevance determination in respect of Mr. Ndou's evidence, following which I paused the inquiry and consulted with the committee. This is not how it happened. The inquiry was not paused in order to make a determination on relevance. The issue raised by the evidence leaders was that there were allegations of sexual harassment made in relation to Mr. Ndou in circumstances where he had not been found guilty of any such charges. There was a concern that private, sensitive, and confidential information should not be subject of a public broadcast, and that the rights to privacy and dignity should be respected, requiring that the evidence, if led, should be treated differently from that of other evidence and other witnesses. It was requested that the questions relating to the sexual harassment charges be done in a closed forum, alternatively that they not be allowed at all. As Rule 1842 of the rules provides, a decision on whether the committee should proceed by way of a closed session is a decision to be taken by the committee. A closed committee meeting was convened. The decision of the committee, which was taken following legal advice, was relayed to both the PP's legal team and evidence leaders, and was to the effect that Advocate Mpofu would be permitted to cross-examine the witness in an open forum, and should he at any stage seek to cross-examine in relation to the sexual harassment charges, for those limited questions, the session will be closed. The request from evidence leaders that the question in relation to the sexual harassment not be allowed at all was not granted. As it turned out, there were no questions asked that necessitated the hearing being closed. Paragraph 33.2, the PP alleges that I allowed evidence leaders to lead witnesses for whatever duration they want, but then unduly curtailed her cross-examination. The application does not cite any examples of this alleged differential treatment, which is therefore completely unsubstantiated. The evidence leaders have questioned the witnesses in a limited time period, whereas the PP's legal team has taken considerably longer and in almost every instance been afforded more time. It's on record. One example of the treatment afforded to the evidence leaders and the PP's team is with reference to Mr. Johan van Lochrenberg. Mr. van Lochrenberg was not sought out by the evidence leaders. This is important. He prepared his own affidavit with his own legal team, which he submitted when the committee called for input from the public. Based on the submission, he gave oral evidence over 3 days. He had indicated that he was only available until 1500 hours every day. On the first day, he was questioned by Advocate Bauer as for just over 3.5 hours. On the second day, Advocate Mpofu took 47 minutes to put issues on record and questioned him for approximately 3.5 hours. His cross-examination was not complete, and so I allowed it to roll over to the third day. At the commencement of proceedings on the third day, I indicated that we should aim to conclude with Mr. van Lochrenberg by lunch, so that the next witness could commence giving evidence at 2. Advocate Mpofu indicated that he was only going to cross-examine Mr. van Lochrenberg on 5 topics, which he completed after the lunch adjournment, taking an additional 3 hours. Mr. van Lochrenberg had to push past his own time limits to accommodate members' questions once Advocate Mpofu concluded his cross-examination. 3 members were unable to pose their questions to Mr. van Lochrenberg orally, but instead put them in writing, and these were subsequently comprehensively answered. When Advocate Mpofu was unnecessarily interrupted by members, I directed them to desist. The committee was not able to engage with another witness on the day in question, other than to pose unanswered questions to the PP due to the time taken by Advocate Mpofu with Mr. van Lochrenberg. Another example is the very first day of proceedings. The evidence leaders addressed opening remarks to the committee for approximately 35 minutes, which included interactions with members. The rest of the day's proceedings were taken up with Advocate Mpofu's opening address and his engagement with members. Advocate Mpofu's address dealt with various points that were not strictly before the committee, including the president's decision to suspend the PP, which falls outside of the ambit of the committee powers and function, but he was permitted to continue, as this was the start of novel proceedings. I granted the latitude. After having addressed the committee for more than 90 minutes, Advocate Mpofu indicated that he was winding down. He then spoke for another 25 minutes or so after winding down. After the lunch adjournment, Advocate Mpofu engaged with the committee for a further period, close to 2.5 hours, in response to the issues raised by members. When Advocate Mpofu was interrupted by members, I directed them to wait to let him complete his statement. When I indicated to Advocate Mpofu that he needed to wrap up because of the length of time he had been speaking and because he was traversing territory already covered, he requested an indulgence to speak further, which I allowed. From inception, therefore, the PP's legal team has been granted far more speaking time, even longer than they have requested, and been permitted to speak on a much broader range of issues, more than the evidence leaders on both counts. A third example relates to the committee's sittings in late July 2022. I explained to the committee on 15 July 2022 that the PP's team would be unavailable for committee hearings from the 20th to the 26th of July 2022 in order to prepare for and attend the High Court hearing. This allowance had been raised at inception, and the schedule was devised to allow for these dates to be accommodated. Notwithstanding the pressing importance of the committee's work, the need to discharge the committee's function with expedition, and the inevitable disruption it would create for members, I do keep time records. The evidence leaders have not been afforded more favorable time allocations than the PP team has. And we have that to prove on record. The latter has not been unduly curtailed. If anything, the PP's legal team has been repeatedly indulged on this score. There have been times where I have allocated less time to evidence leaders than what they would like. Even in circumstances where Advocate Mpofu indicates how much time he would require, he has repeatedly gone over the allocated or self-imposed times. Time allocation are hence not a basis on which to claim I'm either biased, nor do they give rise to a reasonable apprehension thereof. Paragraph 33.3, given the lack of specifics, I'm not able to deal with this allegation. This notwithstanding, it bears stating that at no stage have I made decisions on the evidence leaders' written submissions to this committee, nor have I added input to them as appears to be what is alleged. Paragraph 33.4, the PP alleges that I confer with and rely on the evidence leaders in making decisions while excluding her legal team. I directed the evidence leaders and the PP's legal team to engage each other through what has become known in these proceedings as the backroom, aimed to avoid matters taking up committee time that can be resolved outside the proceedings. The one example cited by the PP is a letter she alleges was clearly written or heavily influenced by the evidence leaders because it included information that had exclusively been shared with them, which she shares undue collusion. Included in the backroom process is Ms. Fatima Ibrahim and the committee secretariat, who would generally relay the outcomes of these meetings to me. I then confer on legal aspect with Ms. Ibrahim as I deem necessary. I thought it was working well in that the hearings had consistently been running in a fairly collegial manner and without any serious delays. Where such discussions only involve counsel, this would either be relayed to me by Ms. Ibrahim or by the evidence leaders. The allegations in the recusal application are a mischaracterization that does not bear scrutiny. The PP wrote to me to request an adjustment of the committee's program. This was a scheduling matter, and therefore something that could probably be canvassed in the backroom. The evidence leaders had been directed to inform the PP that the committee would in fact be convening on the 13th of September. The evidence leaders and the PP's legal team engaged about the committee's hearing during the week of 13 September 2022. The evidence leaders relayed the PP's position to the parliamentary legal advisors, and I was then informed. There is nothing improper about that, especially given that the legal teams by themselves do not determine when the committee convenes. Moreover, as Ms. Ibrahim had taken ill, it was not surprising that factual information was sought from the evidence leaders and that it was provided. The PP's legal team has not been unduly excluded and have not engaged in any collusion with the evidence leaders. To the extent that the letter contained information which solely lay with evidence leader, the letter indicates them to be the source. There was no endeavor to hide such, and it does not present alleged telltale signs of collusion, undue or otherwise. To the extent that the application says this without any clarity on what this was not happening for the first time or even the last time, this is unsubstantiated. No further elaboration was presented in oral argument, and in the absence of details of precisely what I'm being accused of, I'm not able to deal further with this allegation. but as it stands, it doesn't reflect any bias or any reasonable apprehension of bias. Paragraph 33.5. The PP alleges that I've aimed unidirectional hostility and negative remarks at her team, while not censoring similar conduct by the evidence leaders. There are no examples provided of conduct on the part of the evidence leader that required such sanction that I could meaningfully deal with. I've not shown undue impatience with, or shouted at, or suppressed the PP's legal team. Paragraph 33.5 of the recusal application does not cite any examples of my alleged hostility or negativity. On the contrary, I believe that I've been very patient as reflected in the charge to which I refer later. Whilst Advocate Mpofu has said that I should not shout at him, I was not shouting at the time, he says so. I have not shouted at Advocate Mpofu and duly suppressed him. At times, it's been very necessary to raise my voice because various participants in the inquiry have spoken simultaneously or refused to adhere to the rule that they should only speak once recognized by the chairperson. At times, engagement became robust. At all times, I sought to act reasonably and appropriately in the circumstances, and with the aim of preventing the hearings from unraveling into chaos. That is the duty of the chairperson. I reiterate that these are sui generis proceedings and have not been easy to manage, exacerbated by the complexity of the issues. For example, in respect of Mr. van Lochenberg's evidence, Advocate Mpofu cross-examined Mr. van Lochenberg on the 14th and 15th of July, 2022. He accused Mr. van Lochenberg of wasting members' time. He referred to Mr. van Lochenberg's favorite topic, that is the matter on which Mr. van Lochenberg was called to give evidence, the manner in which the PP had conducted her investigation. He referred to his own language as being the product of boundary education. He referred to his, when his language is obviously learned and his vocabulary extensive, and in response to some of Mr. van Lochenberg's evidence, Advocate Mpofu responded, whatever. Advocate Mpofu also referred to the so-called rogue unit, to which Mr. van Lochenberg objected as he found them disrespectful. Advocate Mpofu agreed to merely call it the unit, but then later referred to the rogue unit. One of the members intervened in an attempt to prevent Advocate Mpofu from referencing rogue, but I permitted him to continue. In an attempt at humor, Mr. van Lochenberg indicated that as no one should refer to a rogue unit, he would not refer to a rogue advocate. Advocate Mpofu felt insulted by this comment and took time to address the committee on it and made further reference to it during the proceedings, none of which assisted the committee in hearing evidence, and in circumstances where he had repeatedly referred to the so-called rogue unit, despite having agreed with Mr. van Lochenberg that he would simply refer to it as the unit. I had to caution Advocate Mpofu not to shout at me and not to be aggressive or disrespectful to the members. After a heated exchange with Mr. Mulder about Mr. van Lochenberg's evidence, I also had to request Advocate Mpofu to tone down his language. I also expressed frustration at Mr. Mileham for interrupting me as I was encouraging the wrapping up of Mr. van Lochenberg's examination. None of this reflects any animus against the PP or her legal team. Advocate Mpofu and Mr. van Lochenberg exchanged apologies at the end of the session. That, however, did not undo the conduct I have referred to above or recover any of the time that had been diverted from the committee's function. Another example is in respect of Mr. Tebeko Kekana's evidence. Mr. Kekana sought to make a protected disclosure regarding the PP, which he set out in an affidavit deposed on the 12th of December, 2019, long before this committee began its proceedings. However, when the evidence leaders approached him to give evidence to the committee, he declined to do so voluntarily and had to be summoned. Mr. Kekana gave evidence under subpoena on the 18th and 19th of July, 2022. He was examined by Advocate Bao for just over 2 hours. and then cross-examined by Advocate Mpofu for approximately 6 hours. Advocate Mpofu aggressively cross-examined Mr. Kekana, accusing the latter of being a liar. He referred to him as an expert on oddities, which he then withdrew. This after Mr. Kekana testified as to various actions by the PP that he found to be odd. She put questions to him to the effect that, so you think you are the only person that is right in South Africa? The interactions were tense, with statements being made that Mr. Kekana had moved his lips and something came out of his mouth, but that it did not constitute an answer. In response to one of Ms. Kekana's answers, Advocate Mpofu responded, "Congratulations." During his interactions with Mr. Kekana, Advocate Mpofu indicated that the PP had been portrayed as incompetent by apartheid apologists and clever blacks. Advocate Mpofu devoted a great deal of time to whether or not Mr. Kekana believed that his affidavit fell within the ambit of the Protected Disclosure Act. Advocate Mpofu then told Mr. Kekana, "You are the exact opposite of a whistleblower. You are a whistle inhaler," at which point I intervened, drawing Advocate Mpofu's attention to the directives issues which prohibited bullying, intimidation, and harassment of witnesses, as well as deliberate insults. I protected Advocate Mpofu from interruptions by members in an endeavor to move the cross-examination along, mindful of time. On the second day of Mr. Kekana's testimony, as I had on the previous day, I indicated that Advocate Mpofu should aim to complete his cross-examination by tea time, so that members could have sufficient time within which to interact with the witness who had only been subpoenaed to appear for 2 days. I also indicated, however, that it need be, I was prepared to grant Advocate Mpofu the indulgence of extending his cross-examination until lunchtime. Advocate Mpofu did not conclude by tea time or even by lunchtime. I allocated him 15 additional minutes with Mr. Kekana, which he again exceeded. Another example is the oral submissions on the recusal application. Advocate Mpofu referred to fake outrage and foolish people and infantile arguments and how only racists and their fellow travelers will be upset by his conduct. The examples in the preceding paragraphs are not exhaustive. They merely set out a few instances to demonstrate that as a chairperson, it remained a challenge to maintain a standard of decorum in the proceedings and balance the interests of the PP's team to ask questions, the rights of witnesses to be treated with respect and dignity, the rights of members to actively participate and to ensure that the process is neither delayed nor derailed. This was a daily challenge. As the record shows, it is not an easy balancing act, but it is one that must be done as an imperative. And to do so does not give rise to any bias or perception of bias. The evidence leaders have so far not dealt with witnesses in such a manner or used language that warranted censure. To date, they have seldom sought to interject. Should they do so inappropriately, I will not hesitate to take the appropriate action. Paragraph 33.6. The PP alleges that I instinctively reject her proposals unless they are supported by the evidence leaders and or a member. This is not correct. For example, I've not canvassed the various time indulgences that I have granted to a legal team with the evidence leaders or any members. The only example referred to was in respect of whispering during the testimony of Mr. Pillay, when Advocate Mpofu had claimed that when he raised the issue of someone whispering to the witness, the issue was ignored. But when Mr. Heron raised it, the whispering was addressed. This is incorrect. I had not heard the whispering myself. When Advocate Mpofu initially raised it, he did not say that he had heard answers being whispered. I sought to address the whispering, but before I could fully canvass the issue with Mr. Pillay, Advocate Mpofu interjected without being recognized to speak. I then noted Mr. Heron's raised hand and gave him the floor before responding to the issue, And he also indicated that he had heard whispering. I could only then revert to Mr. Pillay, as the transcript of 5 August 2022 reflects interaction in this regard. And that I will leave for you to read at your own time, the same transcript that you were part of. Paragraph 34 to 37. The PP alleges that I reneged on the arrangement between the head legal team and evidence leaders about a 2-week preparation period before head team begins leading evidence. The evidence leaders cannot bind the chairperson. They communicate requests, and as the chairperson, I ultimately decide based on the program and available days, etc. I never reneged on any arrangement, whether in the form of a gentleman's agreement or otherwise. I've also never issued a ruling that the PP's team would only have 1 day preparation time. The evidence leaders now only have 1 more witness they intend to call for oral evidence before the PP. So the PP is well aware of much of the evidence she has to answer. As matters now stand, the committee last convened on the 21st of September and is likely to only reconvene later in this week, affording a period of more than 2 weeks already to the PP and her team for the necessary arrangement to be made in relation to witnesses. As such, additional preparation time may not be required, but this will have to be determined at appropriate time in future. As early as August 2022, during a hearing of the committee when Advocate Mpofu was in Johannesburg, and he joined the hearing on a virtual platform, whilst Advocate Mkhwebane and Advocate Matlapi were attending the hearing physically in Cape Town, Advocate Mpofu explained to the committee that this division of resources was occasioned by the fact that his team was already then seized with obtaining witness statements, and some of these witnesses were based in Johannesburg. In my view, there is no merit to this ground. Ultimately, once the evidence from the next witnesses has been completed, a fresh assessment can be made as to how much time the PP reasonably requires before a legal team begins leading her witnesses, especially given the breaks in the hearings whilst this recusal application is being considered. Further, in responding to questions during the oral submission in support of the recusal, Advocate Mpofu stated, there was no agreement in the true sense of the word. It was an understanding between us and the evidence leaders and the chair. If it was an agreement, I would tell you, I don't want to accuse people of things that are not there. It was not an agreement, it was an understanding, and Advocate Bauer is right. Even that understanding was not rigid or cast in stone on the 12 tablets. It was a moving target. In the light of this, and given that my stance has been that the time it should go back to the back room for discussion amongst the respective teams. The allegations in paragraph 34 are firstly incorrect, and secondly, not a reflection of any unfairness, unreasonableness, selective treatment, or bias. Ground 5, bringing a constitutional court judgment to the attention of the High Court is not improper and cannot be taken as a show of bias. In any event, it was done on the evidence of senior counsel, on the advice of senior counsel, and the parliamentary legal advisors were in agreement with this advice. The High Court application brought by the PP cited me as a respondent. It is not clear what the precise nature of the impropriety complained of is, or how it manifests as a clear display of my bias when I was drawn into the litigation by the PPSL. During the oral address, Advocate Mpofu stated that I was writing to the High Court to try and influence litigation, which is related to this committee. This is a misconstruction of what happened. Also, I made no statement in relation to the personal cost ordered in the Constitutional Court against the PP that could be cast as being celebratory. It is a Constitutional Court order, and it is what it is. In fact, Advocate Mpofu, as an officer of the court, should have been the first to inform the court of such an order. I was not involved in either the contents of the media statement issued by Parliament, nor part of a decision to issue such a statement. It can thus hardly be construed as a basis for bias against me. Interviews given in relation thereto, if any, by others can also not constitute an actual bias or reasonable apprehension of bias on my part. The sixth ground, rulings on examination. There's been no undue or arbitrary questioning of the PP by members. Members can ask questions even if the PP is not on the witness stand. This emanates from the judgment of the Constitutional Court, which provided that members may ask the office bearer directly to respond to certain questions, even if she's not at the time giving evidence under oath. So it was not arbitrary or biased to allow members to pose direct questions to the PP, who then delayed her responses. I was advised by Ms. Ibrahim that it was within my powers and not unlawful to permit members to engage in general questioning at the appropriate time. I indeed was advised that the questions asked by the members are critical to the oversight and accountability function that the committee is required to discharge. In the respect of Mr. van Lochenberg, as indicated above, I granted Advocate Mpofu an indulgence of more time for his cross-examination, which he utilized to canvass the 5 issues he had indicated he wanted to cover. He completed those 5 points. He then concluded his cross-examination and subsequently noted that he reserved his right to recall the witness if that became necessary. Members commenced their questioning after he was done with his points. In respect of Mr. Pillay, Advocate Mpofu was aware that the witness had availability constraints, it having been made clear that he was only available for 1 day. Mr. Pillay was testifying from Netherlands. For that reason, proceedings commenced an hour early on the day Mr. Pillay was due to give evidence. At the outset, I announced that Advocate Bao would be permitted to question Mr. Pillay from 9 to 12, Advocate Mpofu from 12 to 1600 hours. And thereafter, the members would engage with the witness. In fact, Advocate Mpofu commenced before 12, as Advocate Bao would have finished much earlier, and ended after 1600 hours. The balance of the day was devoted to members' questions, which went on until after 1900 hours that night. The time limits imposed on various parties with an interest in questioning Mr. Pillay were in the circumstances reasonable and appropriate. In respect of Ms. Tejani, members were permitted to question the witness because Advocate Mpofu had indicated he was unprepared to cross-examine Ms. Tejani. I therefore excuse him from having to engage in cross-examination on the day in question at his request, and only members' questions were asked. The PP will be able to assess the full record of members' engagement with Ms. Tejani and would then be able to raise any material with her when cross-examination occurs. The directives have not been arbitrarily applied nor abandoned, but I have to apply them flexibly to cater for the exigencies of any situation which required, for reasons that were obvious at the time, that members permitted to ask questions. This is not tantamount to any manifest bias. During his oral address on the recusal application, Advocate Mpofu claimed that the time granted for cross-examination is insufficient because the PP is granted the same time allocation as the evidence leaders. That is demonstrably untrue, as I would have indicated already up to this point. The time, not just allocation, the time spent. As is evident from the few witnesses discussed herein, the PP is frequently allowed significantly more time than the evidence leaders to interact with witnesses. This has been the pattern with most of the witnesses who have given evidence to date. It has frequently been the case that despite an objection having been raised that the witness evidence is irrelevant to the motion, the witness is extensively cross-examined by Advocate Mpofu on a wide range of issues, some emanating from the motion. The PP argues that unlike the evidence leaders, she's not permitted to ask questions arising out of the questions asked by the members and or the chairperson in terms of the rule, M46, which shows bias. First, this process is not adversarial, nor is this a court. The fact that the rules or conventions of a court are not applied does not make it unfair, nor does it make my rulings biased. Second, the rule permits evidence leaders to clarify issues with witnesses, pursuant to their duty to ensure that a clear and full picture is presented to the committee. Third, where any clarity to be required on any responses given by the witnesses to the questions from the members, nothing precluded being sought through the chair, even by Advocate Mpofu. The PP's final complaint under this heading is that the evidence leaders are not permitted to cross-examine anyone and should never have been permitted to cross-examine Mr. Thembi Nkosimuntu Sithole, a witness that evidence leaders themselves called. This is, however, incorrect. Under the terms of reference, the committee will utilize the services of the evidence leaders, clause 4. Witnesses will be required both to submit written statements and answer oral questions, clause 4.1b. There is no stipulation that those questions may not be posed through cross-examination by the evidence leaders, and there is no stipulation as to the nature of the questions. Under the terms of reference, the evidence leaders are entitled to put any questions to any witness called by the PP, clause 4.4b. For the sake of clarity, the directives made it clear that this would include leading questions. Under the terms of reference, the committee's proceedings are expressly inquisitorial in nature. Pursuant to that inquisitorial nature, the evidence leader's role is to present the evidence and putting questions to the PP or other witnesses with the aim of empowering the committee to assess the merits of the evidence in line with its mandate. That's clause 5. That includes both asking of leading questions and questions pertaining to the credibility of particular evidence tendered. In fact, the nature of the question is not in any way limited. In fact, the Constitutional Court has concluded that there is nothing unusual in an inquisitorial process in the cross-examination of witnesses being done through the chairperson. In the present case, the evidence leaders have been appointed to lead the evidence before the committee in an inquisitorial process. So there is nothing unusual with them engaging in cross-examination when required. The terms of reference also do not stipulate that evidence leaders are limited to examination in chief, as would ordinarily occur in adversarial trial proceedings. Neither do the directives. The directives, clause 6.3, provide for requirements that must be met in order for an evidence leader to opine on the character of a witness. That shows that it is expressly contemplated that an evidence leader may question the credibility or character of a witness. Mr. Sithole's questioning was therefore not the most egregious violation of the directives or any violation. Advocate Bauer's questioning regarding the accuracy and credibility of his evidence was entirely in line with their mandate as an evidence leader, which is first and foremost to assist the committee, and the regulatory framework that applies to the committee. At the commencement thereof, she made it clear that it arose as a result of answers that had been given that conflicted with the direct evidence and questions which required clarification. I refrain from providing any assessment of any witness evidence, as this is not the appropriate time to do so, nor is it material to this recusal application. The attempt to pigeonhole the nature of the questions asked by the evidence leaders into conventional court procedures is not appropriate. As far as I'm concerned, they are afforded flexibility in what and how witnesses are questioned, limited only by relevance. The seventh ground, there's been no skewed or unfair application or abuse of directives, nor are the rulings a product of inherent bias. The PP alleges that almost all the evidence of some 15 witnesses called is irrelevant, but fails to provide any particularity in this regard, aside from indicating that the evidence relates to human resources grievances, I did note that the independent panel stated the following. We do not believe that section 194 of the Constitution or the NA rules exclude misconduct or incompetence in the context of labor relations from being considered at paragraph 183. The witnesses to whom these criticisms are directed are not identified by name, and in any event, it will be inappropriate for me at this juncture to provide any assessment of their evidence. I and the committee am awaiting to hear the PP's evidence. Once the evidence is provided with reference to the motion, an assessment of the evidence in that context in its totality will be done. I'm alive to the fact that some aspects of various individuals' evidence may turn out to be irrelevant. In such instances, such evidence can be discarded during deliberations, and in any aspect, and if any aspect is inadvertently relied upon when it should not be, then the PP should be able to point this out to the committee when she's afforded an opportunity to comment on the draft report prior to it being sent to the National Assembly. Fairness should be assessed in the context of the entirety of the inquiry. In my assessment, there has, however, been no basis to rule from inception that the leading of the oral evidence of any witness led so far is entirely irrelevant and that they should not be heard by the committee, given that it appears from the affidavits that the evidence do relate to some of the allegations in the motion. The fact that I've disagreed with the PP's legal team's assessment of the relevance does not amount to a bias of any kind, nor are these rulings inappropriate or prejudicial to the PP in any way, as she is afforded an opportunity to deal with such evidence, both during cross-examination and also permitted to put other evidence. This is born out of the extensive cross-examination of witnesses whose evidence was initially objected to on the basis of irrelevance. I've also not abdicated my duty to control committee proceedings. I have to balance my various obligations. I've sought to ensure that the proceedings focus on allegations contained in the motion. However, at the same time, I have at all times been bound to allow members their freedom as duly elected public reps and members of parliament to engage with the witnesses. If I do not do so, the next complaint will be that members are restricted in the questions that they ask. Members of parliament are not practicing lawyers and cannot and should not, in their engagement with witnesses, be held to a standard of questioning expected in courtrooms. This must also be balanced against time management, given that there are 36 members of the committee that are entitled to ask questions. Unduly preventing a question from being asked for a response from being given would result in a to and fro of objections. Best avoided unless absolutely necessary, when this could be more swiftly dealt with during the deliberations process. In the circumstances, this complaint does not constitute a ground on which alleged bias or reasonable apprehension of bias on my part. The complaint that the example as referred to in paragraph 53 is a reflection of egregious ruling is not correct. It should be viewed contextually. Ground 8. My previous utterances. I deny that the media article relied on is a reflection of express statements I made that it constitutes conclusive proof that I prejudged the crucial and relevant issue of the public protector's alleged incompetence. I did not provide an interview to the author of the article referred to, nor was I asked to comment. Instead, it appears that reliance was placed on sound bites of a Justice Portfolio Committee meeting that took place on the 10th of July, 2019, at which PP's annual performance plan and budget was considered and discussed. Frankly, I do not even recall the details of this meeting until it was raised by Advocate Mpofu. What occurred at this meeting is the following. I noted that the presentation provided to members of the Portfolio Committee showed that the Office of the PP had done a lot of good work. I asked questions pursuant to my duty to ensure accountability. I did not say that the public record had been incompetent or prejudged anything. It is also taken entirely out of context without regard to the fact that it was an engagement with the PP in which members posed questions and she was afforded the opportunity to respond. I've repeatedly emphasized that the committee and I operate with open minds and I have no predetermined outcomes. For my part, this has been demonstrated by the even-handedness that I've shown in chairing the committee to date. It should also be borne in mind that as prescribed by the Constitution, I have sworn an oath of office to obey, respect, and uphold the Constitution and all other laws of the Republic, which oath binds me to act fairly and independently. I take that oath seriously. The 9th and 10th grounds. The refusal to postpone on the 13th of September availability of legal, relative, and temporary medical unfitness. While waiting for the witness, Mr. Jan on the 13th of September, Advocate Mbofu indicated that he was going to seek a postponement. This had been foreshadowed in a letter I had received approximately 12 noon the previous day, and to which I responded. I was assisted by the parliamentary legal advisors in drafting a detailed 3.5-page letter in response, in which I made the position and reasons for not granting the request very clear. The application for recusal says that my response was a 5-page letter. Well, it was not. As far as I was aware, by the time the committee hearing was to convene on Tuesday, 13 September, there were no papers filed in the High Court that necessitated a response from the PP's legal team that would make them unavailable to do a 1-hour cross-examination of Mr. Jane. I had been informed that it was Advocate Mpofu's estimation that his cross-examination of Mr. Jane would not take longer than an hour. For ease of reference, copies of both letters are attached. In my letter, I propose a way forward, which in my assessment would have alleviated the difficulties raised on behalf of the PP in the letter to which I was responding. I had been informed that the PP's urgent application was only set down for Friday, the 16th September. So there was therefore no clash with the committee hearing on the 13th of September and the urgent application hearing of the 16th. This coupled with the indication that the cross-examination of Mr. Jane scheduled for that day would not be more than an hour, and my assessment that the members' subsequent question would not require a long session. This led me to assess that the hearing could proceed on the 13th. The cross-examination would then remain outstanding, as has now been the case since 13 September, which is not desirable, I repeat. Mr. Van der Merwe's evidence would then be led on Wednesday the 14th, with his cross-examination questioning to stand over to Wednesday the 21st September. This would afford the PP's legal team with additional time to prepare for their hearing in the High Court on the 16th of September. They would have a clear day and a half, same as would have been the case had been the matter had on Tuesday the 13th as they had planned. I also noted in my letter that as the hearings were recorded and fully virtual, they could easily be watched, and it would not have required the PP's entire legal team to be present virtually on Wednesday, 14 September. In doing so, I balanced granting the PP's legal team's request, partially taking into account what had been conveyed to me in their letter of 12 September, as well as fulfilling the obligations to ensure that proceedings are not delayed and parliamentary program is not unduly disrupted by PP's application. In ensuring fairness in the responses, I am obliged to also consider the fair treatment of witnesses and the rights of members and the committee's duties. All have to be continually balanced. If this was acceptable, an application for postponement would not be necessary. This approach also afforded members involved in the litigation, such as the UDM, to consult with their legal representative as requested, as the hearing of 13 September would likely be completed before even a lunchtime adjournment. When the proceedings commenced on the 13th of September, I did not as yet know whether this was acceptable until Advocate Mpofu indicated he wished to proceed with his application for postponement. I allowed him uninterrupted time to address the committee. The submission made by Advocate Mpofu when he commenced his address was to say that he was going to do an application for the postponement, but that the PP was not there because she was ill and was being taken to the doctor. This was a new issue raised that morning. He expressly stated that that was not the reason we were going to apply for this application, but that it was just an additional reason. At that juncture, as it is the case to date on my part, though nothing turns on this, no one appeared to know what the nature of the illness was, whether she would be back from the doctor, whether it was something serious or something which was required immediate attention and she would be back in the hearings. No details were provided beyond that she was going to see the doctor. Advocate Mpofu indicated that the PP was simply not there. He had no instruction to tender an apology on her behalf. He made it clear that the postponement being sought was based on the letter sent previous day, to which I responded. Advocate Mpofu proceeded to set out what had happened since the DA filed an urgent application to the Constitutional Court on Friday, following on the High Court judgment earlier that day, indicating the effect of this was that the High Court judgment was suspended and the PP could not return to work on the 10th of September as she had intended to do. On Saturday, 10 September, whilst committee hearing dealing with Ms. Motsitsa and Mr. Jan evidence was underway, the PP launched an urgent application asking the High Court to make an order for the implementation of an earlier order to allow her to return to work. The High Court dismissed the PP's challenge to the lawfulness of the Section 194 committee, remaining any impediment to the committee continuing its work. I do not comment on the merits of the High Court application, which has since been dismissed, but only deal with its timing and impact on the committee's work. As indicated in my letter of the 12th of September, the PP's legal team sought to set down their urgent application knowing that the inquiry was ongoing and that it was to sit on the 13th of September and 14th of September. In other words, they knowingly set down a High Court application on a day that evidence was to be led before the committee, where they were also participating. The Tuesday had been selected for the committee's hearing precisely because the Thursday and Friday, 15 and 16 September, were unavailable. Advocate Mpofu had indicated that he was not available on those days, 15 and 16 September, as he had commitments in other matters. By selecting Tuesday, cognizance was already taken of Advocate Mpofu's unavailability later in the same week. It is noted that he nevertheless made himself available for the High Court proceedings on the very Friday that he had indicated he was involved in another matter. I had not been told during the hearing on Saturday that the application was set down during the course of that afternoon by a PP's legal team for Tuesday, 13 September. Had this been expressly stated, I would have dealt with it on the Saturday already. All that Advocate Mpofu said was that the situation was such that it could be dealt with in the backroom conversations with the evidence leaders. I had no reason to think it would disrupt proceedings until I was informed on Sunday via a WhatsApp message received from the chief legal advisor, who had in turn received it from Advocate Bauer to the effect that the people were seeking a suspension of the committee's proceedings that week. In the application, it is stated thus that this was based on the non-availability of the PP's legal team as a result of a related emergency playing out in court. Advocate Mpofu, during his oral address, indicated that the PP had been put in the situation of an urgent application which ordinarily would have been heard this morning, being Tuesday, but for other related reasons, it has now been set down for Friday. With respect, based on correspondence that had been made available to the Department of Legal Services, it appears that as of Sunday, 11 September, it was already apparent that no hearing would happen on Tuesday, 13 September, for 3 reasons. The President's senior counsel was not available on Tuesday, and given the nature of the matter, it would not be appropriate to brief another senior counsel. The respondents in the PP's application required time to file affidavits, and these would not be ready for hearing on 13 September. The respondents in the PP's application regarded as extremely prejudicial for a matter to be heard on such expedited timeframes. On Sunday, 11 September, this was not brought to my attention. All I was informed was that there was not yet indication as to whether or not the matter will be heard on Tuesday. As it turned out, the litigating parties, which did not include any legal representatives for the committee or the National Assembly, reached an agreement that it would be argued on Friday, 16 September, based on their availability and given that the court was also available. This, the PP's legal team appeared to have agreed to without any regard to the committee's timetable. Advocate Mpofu SC, during his oral address on the 13th of September, represented that there has been a whole lot of developments and exchange of papers. He did not refer to any answering affidavit as yet having been filed in the High Court proceedings that warranted a response for the Friday hearing, but appeared to make reference to the papers filed for the Constitutional Court. I specifically asked what had to be attended to on that day. Although he did not expressly inform the committee hereof during his address, the DA and the President's papers were only expected to be filed by 9 o'clock on that evening. However, Advocate Mpofu indicated he had since 4 o'clock in the morning been at what I understood to be at his office to meet a deadline for papers to be filed by 9 o'clock, which I understood had to be filed in the High Court by that time. It was represented to the committee by Advocate Mpofu that the situation that they found themselves in was not of their making. But I determined from his own submissions that it was the application brought on behalf of the PP on an expedited basis, setting it down for 13 September that caused the situation. In my view, it was precisely of their own making. There appeared to be no reason that prevented the PP from setting the application down for any day of the week or the following week, so as to avoid any disruption of the committee hearings, and hence allowing Mr. Jane's cross-examination to be completed and Mr. van der Merwe's evidence to be completed. During the oral address, the only reason given as to why the PP's legal team sought to set the matter down for 13 September was because they did not want to disrupt the committee for another week and interfere with the program of the committee. But as the committee had nothing scheduled for the following week, this, with respect, made no sense. Contrary to what was indicated in the postponement application, the PP had not been drawn into an urgent litigation. The PP, in fact, brought an urgent application herself, setting it down on a date on which the PP's legal team knew was a day on which the committee was scheduled to sit. This was no unforeseeable clash of dates. All indications were that the urgent application was not thrust upon them. As indicated, it had been self-created by them that it was self-created. It has been self-created by the date they had arbitrarily selected to set down the urgent application without regard to the fact that the committee was to hear evidence on the 13th and 14th of September. Having deliberately so set it down, the PP cannot now allege that I'm biased for wanting the committee hearings to proceed and for the process to be derailed. The only information provided on the 13th of September that had a bearing on the hearing that day, in my view, was that Advocate Mpofu was busy with papers from 4 to 9 a.m. For that reason, he was unprepared to conduct a cross-examination and communicated this to the committee on that morning, and that the PP was ill and at the doctor. There was no mention of any answering papers that warranted the attention of the PP's legal team as yet. Ultimately, on 13 September, I granted Advocate Mpofu the indulgence of not proceeding with Mr. Jana's cross-examination and not having to prepare for Mr. Van der Merwe's cross-examination that week, and allowed members to proceed questioning Mr. Jana. I did not regard it as unreasonable or unfair to have balanced the interests of the committee with the interests of the PP by allowing Advocate Mpofu not to have to prepare for cross-examination that week, and yet allow the time available to be used sensibly by permitting the members to ask questions of Mr. Tejani and for the evidence leaders to proceed, presenting the direct evidence of Mr. Van der Merwe. In doing so, I balanced the resources at the time and the time available for the committee with Advocate Mpofu's team's need for additional time to prepare for their urgent application, notwithstanding that this has been brought on by themselves. Clarity sought by the evidence leaders. After Advocate Mpofu had addressed the committee, I gave Advocate Bauer the floor, but before she could say anything of substance, Advocate Mpofu objected. When I indicated that he must wait until Advocate Bauer has completed, he converted his objection to a point of order. I was then accused of abusing him. There was no justification for this accusation, as is evident from just the following prescript. So the chairperson. So I indicate you are not ready for cross-examination, Advocate Mpofu, and I will leave that to you to read so that you would have experienced that, you know that. I will skip that. After the tea adjournment and before my ruling, Advocate Mpofu indicated that his team had received a phone call to say that the PP was still at a doctor and that they would not be able to conduct the cross-examination without her being there to assist them. I had already intended to rule that they would not need to do any cross-examination that week, so this did not take it any further. Before I made a ruling, Advocate Mpofu interjected, again without having the floor. I commence with my ruling. You can watch that in YouTube. But prior to the ruling, I placed a number of issues on the record, including that at 12, the preceding day, I received a letter seeking a reconsideration of my decision that the proceedings continue with a 13 o'clock deadline for me to respond thereto, which was not reasonable. Prior thereto, on Saturday, the PP's legal team was informed that the matter would proceed on Tuesday, the 13th of September. It was already understood that the committee would sit on Wednesday, the 14th. The situation came about because the PP brought an urgent application to the Western Cape High Court, setting the application down for Tuesday, knowing the committee's hearings were ongoing. The events were created by this occurrence. The application was to be heard on Friday at the behest of the High Court. I specifically indicated I make no comment in relation to the decision to set the matter down, but to the extent that this decision impacts on the committee's proceedings, it has arisen that this was different to the position that prevailed when the accommodation was made for the High Court proceedings dealing with the suspension that was had on the 26th of July, as those proceedings had been pending and known about when the inquiry program was devised. The committee will not sit on days which court is to hear matters as we did in the past. But what is now being sought is different to that. Based on Advocate Mpofu's submissions, it appears evident that what is being sought may have a knock-on effect which could negatively affect the proceedings going forward. Advocate Mpofu has indicated that he's not ready and explained the circumstances. And in the light of that, I granted his request, and I then proceeded to state the following. And I would like you to read that at your own time. Events after the ruling was made. I proceeded to invite members to ask questions of Mr. Jan after the ruling, I noted Honorable Member Gondwe and Mautwe. Advocate Mpofu raised his hand and he indicated that he had raised his hand in seeking clarity and that he did not understand the ruling. I made it clear that the cross-examination would be postponed as per his request. This was because Advocate Mpofu was not ready, but I did not want the committee to be delayed. Advocate Mpofu stated that the continuation to be a contradiction and that he could not understand how it could continue on the next day. Clearly, I had not allowed for the request for the committee to continue on the following day. I indicated that the people was not have a right to intervene in the questions that are asked by members, which requires conference with a legal representative. As Advocate Mpofu cross-examination was going to be delayed, that afforded them every opportunity to consult and for any issue to be raised with the witness in cross-examination. There was no contradiction with what Advocate Mpofu had indicated was my ruling. As for the next day, it was quite clear that I ruled against the application for postponement, but I had mitigated this by indicating that Advocate Mpofu did not need to cross-examine and then proceeded as follows. And here are the exchanges. I would leave you to read those. They are in verbatim, in detail about what would have happened on that day. The 11th ground, rejection of members' request to be consulted. The members' requests were not unduly rejected. I invited all members to make submissions and to raise any issue they wanted to raise. Various members had done so and then continued to do so, including Dr. Locktrich, Mr. Mulder, Ms. Siwela, Ms. Mautwe, General Olomisa, Mr. Zungula, and Ms. Lakude. There were no dictatorial tendencies, manifest bias, or disqualifying impropriety. The PP's application was partially successful in that I granted the request to postpone the cross-examination. The fact that the PP's application was not wholly successful cannot be taken as evidence of bias or unfairness. The 12th ground. The PP alleges, these are statements made in the public domain, that I presented false facts during 2 interviews.
Chair.
These were not
Chairperson.
identified as such.
Chairperson.
I'm unable
Chair.
to deal with such situations.
Chair.
Yes, Honorable Maute.
Yeah, there's a problem with your mic. We can hardly hear you. It's going up and down.
Can you hear me now?
Yeah, now I can hear you. If you keep it that way, we'll be able to hear each other. Thank you.
Okay. Thank you, Honorable Maute, for bringing that to my attention. Maybe at that point, let me take water.
Cheers.
Cheers, Honorable Maute. The PP alleges that I presented false facts during 2 interviews. These were not identified. As such, I'm unable to deal with such allegations. For the avoidance of any doubt, I did not present any false facts. The claim is both baseless and untrue. The PP also alleges that I called for Advocate Mpofu to be investigated by the Legal Practice Council, LPC, for allegedly threatening me, which restated the unduly hostile position adopted by certain political parties. Again, this is incorrect. I should note that Advocate Mpofu's utterances are not mere allegations, but were viewed on a live broadcast by much of the country and confirmed by him during the proceedings. His intention during the hearing was something that he expressly said, by first confirming it to be a threat, and thereafter clarifying that it was a promise. I did not replicate the stance of any particular political party, nor did I adopt an unduly hostile position. During an interview with Newsroom Africa, the interviewer had asked me a question about Advocate Mpofu, and I responded. I did not issue a call for Advocate Mpofu to be investigated by the LPC. I merely noted that the LPC, the Legal Practice Council, as the professional body responsible for the ethics and behavior of legal profession, would address Advocate Mpofu's conduct if in fact anything warranted attention by that body. And I would have elaborated and said their rules allow them to not even wait for any investigation once it is done in the public in a transparent manner. I made the point that whatever the interaction may have been with Advocate Mpofu, the committee should not be distracted from its important work that is engaging with and assessing the evidence in respect of the various charges in the motion. At no stage did I say that the PP's legal team should be removed or that the PP should be stripped of her right to legal representation. For the avoidance of any doubt, I've personally not laid any complaint, not taken any steps to initiate an investigation into Advocate Mpofu. All that I indicated in the interview was to point out that he is regulated by a professional body, and if they feel he has to account, then they must call upon him to do so. I did not show or possess any lack of impartiality or negative attitude. I regard my response to have been reasonable in the circumstances. The committee is undertaking an unprecedented process. Never before in South Africa has a Chapter 9 office bearer faced an inquiry under Section 194 Constitution. It has received inputs from members of the public through a public participation process, and its proceedings take place daily in full view of the public, as it is happening today. The committee is large, in fact, the largest committee ever to have been established in our constitutional democracy. This creates logistical challenges, which as a chairperson, I try to manage to the best of my ability, both in scheduling, especially when Parliament is in session, and during the course of a meeting. The committee is also required to traverse voluminous evidence. The motion alone refers to numerous judgments, affidavits, and court records, apart from documentation that the evidence leaders provide in the bundles uploaded to the Dropbox folder and shared with the PP. The Constitution provides that members of Parliament must determine whether the public protector has misconducted herself or been incompetent as alleged. No courts of law, not administrators, not quasi-judicial bodies, members of Parliament. The committee's process is something that is exclusive to Parliament and to its members who are not lawyers or bureaucrats, but are directly elected representatives of the people. The Constitutional Court has also determined that evidence may be laid and tested through cross-examination. That is not ordinarily how parliamentary committees receive information, nor is there a precedence for how this should unfold in the parliamentary context. The committee's proceedings are therefore substantial and complex, where some aspects may only be addressed and when they arise. The inquiry must be conducted diligently and without delay. All of this means that if the committee is not to unravel, it must be managed firmly and fairly. This is what I've endeavored to do, I've called Advocate Mpofu to order when necessary, but more often than not, have allowed him significant leeway for the sake of progress. I have called members to order when they have been unduly disruptive. And I have not acceded to objections by evidence leaders when I deemed it appropriate. All in all, I have no doubt that I've been fair, reasonable, firm, and balanced in seeking to ensure that the committee discharges its fundamental constitutional function. There is therefore no substantive merit in the recusal application. I am confident that every stage of this process I have acted with integrity and have sought to ensure that the process is fair to the PP, to the witnesses, to members, the evidence leaders, and the public alike. On that note, I pause and I'll ask that we take a 15-minute break. We come back and proceed from there. I thank you.
Recording stopped.
complete the offloading of these matters, allowed 2 short briefings, not as long as the chairperson. It's very few minutes, summaries, so that thereafter I'm able to invite members to engage. So the 2 items is I'll call Honorable Mileham to put on record what he would have done in writing briefly. And thereafter, I'm going to ask Fatima Ibrahim to give us a summary of the legal opinion. Thank you. In that order, Honorable Mileham.
Thank you, Chairperson. Chairperson, on advice received that recusal is personal in nature, in other words, that one must recuse oneself, I hereby advise that I have no intention of recusing myself from these proceedings. I shall lay out my reasons for this decision below. The Public Protector in her application suggests that I have, quote, an inherent bias, close quote, given the nature of my relationship with the complainant. It is indeed common cause that I'm married to Honourable Natasha Mazzoni MP, having been married since 10th July 2017. At various points in the proceedings, it has been suggested by the Public Protector's legal counsel that I have failed to declare my relationship with the complainant. This is untrue. My relationship with Honourable Mazzoni has been and is declared annually since the date of our marriage in the Register of Members' Interests. Furthermore, our marriage was celebrated in Parliament during a sitting of the House in August 2017 by Honourable Baleka Mbeki MP, then the Speaker of Parliament in South Africa. This is on record in Hansard. Given the public nature of these declarations and House proceedings, it cannot be said that Parliament or its members generally were unaware of our marriage. As a member of Parliament, I have on 3 separate occasions sworn an oath to be faithful to the Republic of South Africa and to obey, respect, and uphold the Constitution and all other law of the Republic. Furthermore, I have solemnly promised to perform my functions as a member of the National Assembly to the best of my ability in terms of Section 4(1) of Schedule 2 of the Constitution of South Africa. In this regard, I am no different from any other member of Parliament and must put aside personal interests to serve the best interests of the country. I reject the idea that I am a member of a member and or that I am unable to think independently and impartially on this or any other matter. I do not take instruction from Honourable Mazzoni in regard to this matter, and we do not discuss it in any detail whatsoever. The recusal application goes on to note that I am hostile and condescending towards the legal representative of the Public Protector. Chairperson, I point out that I have been unfailingly polite to Mr. Mpofu, who has in turn ranted, shouted, and told me, quote, shut up, Mileham. Chairperson, I want to pause at this point to bring to your attention that if I had used those kind of words towards Advocate Mpofu, I would have been ruled out of order immediately on the basis of an objection, and yet he was allowed to get away with it. I've raised a number of objections to Mr. Mpofu's behavior and attitude towards the committee, its members, the chairperson, and the witnesses. None of these imply any inherent bias towards the Public Protector, but rather are a response to the shameful behavior of her chosen advocate. With regard to the second ground of application, namely my remarks on Twitter, I note that throughout the chain of tweets, I did not comment on the Public Protector's fitness to hold office at all. Instead, I limited my comments to Mr. Mpofu's behavior and noted that, quote, I haven't made up my mind on Advocate Mkhwebane's fitness to hold office yet, close quote, and, quote, none of which indicates that I cannot consider the evidence before me with an open mind. I have not yet reached a conclusion and will wait and see what argument and evidence is still to be presented before deciding how I will.
2 hours to deliver his response to those dirty dozen reasons why the public.
Apology, Honourable Mileham. Somebody is reporting somewhere. That's a member of the media.
Chairperson, I'll go back to the start of that
please
quote.
proceed.
Quote, none of which indicates I cannot consider the evidence before me with an open mind. I have not yet reached a conclusion and will wait and see what argument and evidence is still to be presented before deciding how I will proceed as part of the committee, close quote. It must be pointed out that all of the tweets were in reply to tweets from others. I did not initiate these discussions, nor did I seek to promote a particular position with regard to the impeachment process. I'm unaware of why the comments of the DA's leadership or the fact that the party included various public documents in its court papers should have any bearing whatsoever on my ability to perform my duty impartially. Furthermore, it is difficult to fathom why the DA and its members should receive special scrutiny in this regard, when other political parties and their members have been particularly vocal about the fitness of the public protector to hold office, both for and against. I reiterate that I will consider the evidence before me at the conclusion of the inquiry, and at that point will draw my own conclusions in this regard. I trust that this clarifies my position. I assert my rights to participate in these proceedings as a full member of the National Assembly, with all rights, obligations, and privileges associated thereto, and reject any call for my recusal. Thank you, Chairperson.
Thank you, Honorable Mileham. I proceed straight to invite Ms. Fatima Ibrahim to give us a summary of the legal opinion. Ms. Ibrahim, can you hear us?
Yes, Chair. Thank you, Chair, and good afternoon to all the members and everybody else on the platform. Chair, in the last meeting, our office was directed to go and seek an external legal opinion on the merits and the legal effect of the recusal application against yourself and Honourable Mileham. Our office then procured the services of Advocate Ismail Jamie SC to provide this opinion. Chair, this is a procurement process that happens at the level of our office and that involves the Secretary to Parliament. Neither the Chair nor any other politicians play any role in that process. We had approached various counsel to provide us with this opinion, but for differing reasons, other persons approached were not able to provide the opinion. That being said, Chair, Advocate Jamie is a member of the Cape Bar Council. He is well aware of the prescripts that would be applicable in terms of conflict of interest and declaring same, and he had declared no such conflict. In fact, he has chaired that Bar Council. He also serves as a member, as I understand it, of the Legal Practice Council, which is the body in terms of the Legal Practice Act, which is responsible for dealing with such issues as conflict and so on, the behavior of legal professionals. So there was no reason for us to believe, Chair, as now is being asserted, that Advocate Jamie had any conflict. And indeed, Advocate Jamie has acted for the DA, as I'm sure he's acted for many other parties and many other institutions. There's nothing unusual about that. Council is by no means limited to only act for one party or one person. Mr. Jamie is not the advocate of the DA. He does not work for the DA or for any other particular party for that matter. Also, Chair, I just want to emphasize something that we've been saying from the beginning. This motion is not a DA motion, and I think it's important that we need to move away from that discourse. The motion was adopted by the House. It is now a motion of Parliament. So whilst it may have originally been initiated by the DA, it's certainly not a DA motion that is before this committee. Chair, the opinion was prepared by Advocate Jamie with the assistance of Advocate Adil Nasiruddin, who is also an advocate at the Cape Bar. Members would have a copy of the opinion. It is self-explanatory, so I'm going to try not to go into too much of detail. The first issue that we asked Council to advise on was what the legal test for bias would be in terms of the current proceedings, which are sui generis proceedings. Because we noted to Council that these are not judicial or quasi-judicial proceedings. So we wanted advice on what the appropriate test would be to apply. Council advised that this committee is a fact-finding committee, which essentially must reach conclusions based on the evidence and the material presented to it. And so the fact that this committee comprises of politicians does not detract from that responsibility of ensuring that they do not bring to this fact-finding inquiry their own biases or political views. That being said, Council emphasised that it is not expected that members may not have prima facie views, as long as they keep an open mind and honestly and fairly evaluate the evidence before them. Based on this, council was of the view that the test for bias is the test as articulated in the BTR case, which was a Supreme Court case and which is commonly referred to as the reasonable suspicion test. This is a test that's also been accepted by our Constitutional Court. Briefly, the test requires that there must firstly be a suspicion that a judicial officer might be biased. The suspicion must be that of a reasonable person in the position of the accused or the litigant, in this case being the PP. The suspicion must be on a reasonable grounds, and the suspicion finally must be a suspicion that a reasonable person would have. So this is a test that would need to be implied. Importantly, the opinion also emphasized the fact that the person who alleges the bias carries the onus of establishing that bias. The opinion then considered the 12 grounds. I know, Chairperson, you've gone into detail in respect of your own responses to those grounds. So I'll try to keep this fairly short. In respect of the scope of inquiry, members will recall that revolved around an accusation that the chair failed to narrow the scope as per the findings of the independent panel. The advice accords with the advice previously given by our office that neither the chairperson nor the committee had the power to narrow the motion. Therefore, that ground did not establish bias in the view of council. The second ground had to do with the unilateral amendment of directives. And Chair, I had dealt with this in our last meeting, where I explained to members what had happened in terms of the misunderstanding with the correspondence that had flowed. And here council agreed that this did not form a ground that could establish bias, because in fact those directives were never adopted. But also council importantly noted that one of those two draft directives favored the PP procedurally, so it could hardly be said that the chair would be biased in wanting to adopt such a directive. The third ground was around the refusal to subpoena the president. Here, council also found that it cannot be attributed to the chair when the decision, in fact, was a decision of the committee, and that the chair enjoyed no powers to unilaterally make a determination on whether the president should be summoned or not. The fourth ground was an allegation that the chairperson unduly favors the evidence leaders, that there is an unwarranted proximity to and collusion with them, in addition to the adoption of an oppositional posture to the PP and her legal representatives. So council importantly noted that this ground was very vague. It was made in broad terms and didn't contain the necessary detail to substantiate the allegations. As such, council notes that it was difficult to assess, save for them considering the transcripts and audio-visual recordings. But given the length of such recordings, of course, they couldn't watch it in its entirety. They note that the evidence leaders made far fewer objections than the PP's team did, which would explain why the PP's team was overruled in more instances. They were of the view that the evidence leaders were not given more time than what the PP was given, and that generally, in fact, the PP had more time to cross-examine witnesses than what the evidence leaders had to lead those witnesses. They noted further that the mere fact that the evidence leaders may have conferred with the chair in and of itself is not indicative of bias, and no facts were provided to substantiate the nature of those engagements. Council noted that from their consideration of the proceedings, they did not observe the chair to have shouted at Advocate Mpofu. So those were just some of the issues that were raised under that ground, which council also felt was not substantiated. The next ground was undue comments and interference in High Court proceedings. And that ground concerned the papers filed by the Speaker and the Chairperson in the High Court litigation, in terms of which the Constitutional Court order dismissing the second rescission application was brought to the attention of the court. And in addition, in terms of this ground, reference was also made to a media statement that was released by Parliament, which was said to have celebrated the loss of that rescission application. Council found that even if Chair did instruct the filing of that particular application, this could not amount to bias, as the Constitutional Court order was relevant to the proceedings that were currently before the High Court. In addition, the chair played no role in the issuing of that media statement, which was in fact done on behalf of the Speaker by the spokesperson of Parliament. The sixth ground, Chair, related to rules relating to cross-examination and re-examination. And there were various complaints here under, which included that members were allowed to ask questions before cross-examination had been completed. The PP was asked questions during the process, and the fact that the chair allowed the evidence leaders to cross-examine a witness. Council, on consideration of the facts against the rules of the Assembly and the directives governing the process, was of the view that none of those gave rise to any reasonable apprehension of bias. The seventh ground was a ground relating to rulings on issues of relevance, where the PP alleged that by allowing evidence related to legal costs and human resources, these were irrelevant and therefore showed that the chair was biased. Council was of the view that both of those matters are in fact covered in the motion. And in respect of the chair allowing members to ask irrelevant questions, Council noted that members are laypersons and the chair understandably must afford them some leeway, and that evidence would have to be considered at the end of the hearings to determine its admissibility. Thus, the chair's rulings in this regard have not given rise to any bias or reasonable apprehension thereof. The eighth ground, Chair, was in respect of previous utterances made by the chair, and this related to statements made by the chair during oversight proceedings in the PC Justice, of which the chair is a member. And Council was of the view that those statements were made before the initiation of this 194 process, and in the context of conducting oversight in relation to the annual performance plan of the PPSA and its budget. In light of the principle that a decision maker must have an open mind and absolute neutrality is not expected, coupled with the fact that the entire committee in this process will make a decision rather than the chairperson on his own, Council was of the view that this ground also fails to meet the requirements for the test for biasness. The ninth ground, Chair, had to do with the refusal to postpone the meeting of the 13th of September based on the availability of legal representatives. And here Council found that this ground must fail as it was not supported by the facts, and there was no impediment preventing the PP's team from appearing that day, as the legal representatives were in fact available and the court was not sitting. The 10th ground, Chair, relates to the previous one. It's got to do with the same meeting, but on the basis of the chair's refusal to postpone the meeting based on the temporary medical unfitness of the PP. And Council here, on consideration of the facts, found that the chair took a considered approach and that the ground was not established. The 11th ground was the rejection of requests by members to be consulted, and that had to do with consultation that certain members had requested in that meeting as to whether the meeting should be postponed or not. And here Council was of the view that if such a request did not have the support of the majority or was not properly motivated, then the chair was within his powers to refuse that request from those members. The last ground was misrepresentations made in the public domain, where the chair is alleged to have publicly called for an investigation by the Legal Practice Council into the conduct of Advocate Mpofu during the hearings. And here Council found that if the chair simply referred to the exchange and the fact that the LPC may want to investigate Advocate Mpofu rather than himself calling for such an investigation, that conduct cannot be regarded as objectionable. That was how Council dealt with the grounds raised against the chair. Then moving on to the recusal of Honourable Mileham. The recusal request was based on two issues. Firstly, Mr. Mileham's marriage to Ms. Mazzoni, who initiated the position in her then role as former Chief Whip of the DA, and then certain statements made by him on Twitter. They also made mention of the party's general attitude. Council advised similarly to the legal opinion chair finished by our office that the mere marriage does not justify the inference that Mr. Mileham has already reached a conclusion on the matter. Such an assumption is devoid of facts to support, and there is no evidence in the transcripts of Mr. Mileham already having determined the outcome of the matter. In respect of Twitter, Council reiterated that the personal animus between a member and a legal representative is not enough to give rise to a reasonable apprehension of bias in respect of the member against the PP. So that was an important aspect in the opinion, that the engagements between the PP's legal representatives and any member, including the chair, cannot in and of itself be said to be or give rise to bias against the PP unless that is supported by the facts. Thus, in regard to the analysis, the opinion concluded that the PP had failed to establish that either the chairperson or Mr. Mileham are biased, or that there is a reasonable apprehension of bias. In terms of the way forward, Council agreed with the previous advice that we gave to this committee, that the matter should be considered individually by the chair and Mr. Mileham, who must consider based on their own conscience whether they are biased or whether their conduct may give rise to a reasonable apprehension of bias. And if so, they must recuse themselves. We are now aware that both the chair and Mr. Mileham have indicated that they have no intention to recuse themselves. However, the committee must now as a whole determine whether the committee is satisfied with the response given by the chair and Honourable Mileham and reach its own conclusion, whether they are of the view that they are biased or whether their conduct may give rise to a reasonable apprehension of bias. If members are of the view that there is no basis for their removal, then the proceedings can simply continue. If, however, members are of the view that either Mr. Mileham or the chair must recuse themselves, then Council has advised that that is a matter that must be resolved in terms of the rules and through the whip system. And I did speak to this in the previous meeting. So, Chair, what is left now for the committee to determine is whether they are in agreement with your submissions and the submissions of Mr. Mileham, together with the advice in the legal opinion, so that we can determine the way forward. If the committee is of the view that either yourself or Mr. Mileham must be recused, then we will provide further advice on the correct procedure to be followed, and that will be done in consultation with the procedural advisors. Thank you, Chair.
Thank you, Ms. Fatima Ibrahim, for that. That's an 87-page document that you took, unlike the chairperson, very few minutes to summarize it. So thank you very much for that work. Thanks to you, and thank for the presentation also from Honourable Mileham. Honourable members, I now turn to you for your comments, contributions, questions that you want to, having listened to the three presentations that have been made in line with the purpose of this meeting. I recognize the following hands. Honorable Olomisa will be first up, followed by Honorable Jakude. Honorable, I see the house is fine, there are no hands here. Honorable Mola. Mananiso. Zongula. Hendricks. Lothrit. In that order. Let's start. Honorable Lamisa. Honorable Holomisa.
Chairperson and colleagues, can you hear me?
Yes, we can hear you, Honorable Holomisa.
Thank you very much. We have just received your response, and it was also sent to us an hour ago. It's a lengthy report, and I would ask that we be given at least a day or two to go through it to avoid further delays in this inquiry. I would suggest that those who will not be satisfied with the chairperson's refusal to recuse himself should appeal to the speaker and whips and also, of course, to the National Assembly. And they should also seek, if they are not satisfied, that's their right, seek a legal advice or opinion. Otherwise, we will be tainted with this illegality. Lastly, I heard the legal advisor who seemed to be wanting to respond to the point I raised at the beginning. I thought she was asked to respond on a legal opinion sought from outside. If we were satisfied with the caliber of the legal advisors we have in Parliament, we would have not said we want a legal advice from outside. So, but we will deal with that matter later on. Thank you very much.
I didn't understand your last point, but maybe we'll check that. Thank you, Honorable Holomisa. Honorable Lafude.
Thank you very much, Honorable Chairperson. Good day, colleagues, and Fatima.
Sure.
Your network is weak. Please switch off your camera. Honorable Lagude, just reposition yourself. We'll come back to you. We'll come back to you, Honorable Lagude. Your network is weak. Just find a better place. Thank you. Honorable
Chairperson, let me start by welcoming your. Okay, thank you. Thank you, Honorable Chairperson. Let me start by welcoming your Honorable Chair. Okay, Chair, I'll do so.
Oh, okay. It take long. Okay, thank you, Honorable Nola.
Thank you very much, Chair. Let us indeed welcome your address, that of Honorable Mileham, and the legal opinion. Chair, I think I can only say all the three are in coherence with my submissions in the last meeting. So I need not to go to the merits and the detail of what has been said. But just say, I move that the committee accepts your address, that of Honorable Mileham, and the legal opinion. So we move forward to the inquiry, because failure to do so, Chair, will actually be a breach of the rules that direct us that we must conduct this inquiry within a reasonable time. Failing to conduct this inquiry within a reasonable time, Chair, would actually amount or cause a prejudice to the public protector. So, Chair, I move that we must accept all the three as the committee and go back to the program of calling witnesses and proceed with the inquiry. Thank you very much.
Thank you, Honorable Bolangwala. Those brief remarks on your comments and already also moving for the acceptance. I now recognize Honorable Jane Mananiso.
Okay, thank you, Chairperson. Let me start by welcoming all the presentations and as well the responses from yourself and Honorable Mileham. And one must say that I'm very satisfied in terms of responses given because it was based on the ground as presented by Honorable Advocate Dalimpofu. Chair, one is agreeing for the fact that the PP has not laid down a factual basis for the inquiry. Chairperson does not take final decision relating to impeachment comprehensively by the committee. PP still has an opportunity to refute all the evidence presented. The committee makes recommendations which can be rejected by the NA. Allegations of predetermined outcomes by the chair are therefore not manifestly prejudicial towards her. So one would want to agree that let us continue with the inquiry. And from my side, you have not been biased to anybody and you've been exercising by all costs fairness in this particular process. So I want to thank you and as well agree for the fact that you have eloquently responded to the recusal application. Thank you.
Thank you, Honorable Mananiso, for your contribution. Well noted. Honorable Zungula. Honorable Zungula, you are recognized. Honorable Vuyo Zungula, please unmute yourself. You have the platform.
Thank you, Chair. Been having network issues. Chairperson, from my side, whilst one can note your response, including Honorable Mileham, the issue becomes with the independent legal opinion. I would like to raise, even though the advice is that the legal opinion is independent, but my view, Chairperson, is that if the advocate who did the legal opinion, as they close as they are with, with the party that brought the motion, whilst I get the sentiment that this is a motion of the House, sorry, it is a resolution of the House. However, this motion would not have been, in the discussion and the proceedings of Parliament if it was not brought about by a political party called the Democratic Alliance. Therefore, in my view, there's no way in which you can divorce the Democratic Alliance as a people or as a party that brought about this motion via their whip, Honorable Mazzoni, and this particular process. So in those grounds, Chair, I want to put it on record that as the ATM, we disagree with the notion that the independent legal opinion is truly independent, because it has been done by a person with relations, with a person that is who has represented the original movers of the motion to Parliament. If it was a person or an entity that has got no business with any of the political parties in Parliament, then would have a reason to believe that it might be independent. So I wanted to put that on record, Chairperson. Thank you.
Thank you, Honorable Zungula, for your contributions. Well noted. I now recognize Honorable Hendricks. Honorable Hendricks, you are recognized. Honorable Hendricks, can you hear us? You are recognized to speak. Is Honorable Hendricks still on the platform?
Yes, he is on the platform,
Unmute
Chair.
yourself. Please unmute yourself and take the platform. Honorable Hendricks. Okay, we will proceed and recognize Honorable Lothrit.
Thank you very much, Chairperson. I will firstly not deal with the matter of the slight made concerning the integrity and independence of the legal professionals responsible for the legal opinion. But Chair, I have listened very carefully to your response, as well as that of the Honourable Mileham. And I have to state here that I truly believe, given the substance of the replies to the request for recusal, that all the grounds were answered sufficiently, adequately, and in depth. And I do not think, based on the responses by both you as well as Honourable Mileham, that the grounds for recusal can stand. And therefore, from my side, I do not believe that there's any necessity for yourself or the Honourable Mileham to recuse yourselves. Thank you.
Thank you, Honorable Lothrit, for your contributions. Honorable Mautwe, you're next.
Oh, thank you very much, Chair. So, Chair, firstly, it's unacceptable that you receive your response while sitting in the meeting, actually an hour into the meeting. Why was your submission not emailed the same time with that illegal legal opinion? So it's unacceptable. Your office must really improve on that. How are we going to contribute fairly on this process when you only get documents while sitting in a meeting? It's unacceptable, Chair, and I think you must reprimand your office. Now, Chair, you know, the majority vote doesn't mean that the majority is actually correct legally. Numbers don't have brains in law. What matters in law is how you argue the law and not the numbers. So it doesn't matter whether ANC and DA jointly with their friends FF Plus agree on this, but if it's legally incorrect, it's incorrect. So, Chair, we want to put it on record that as the EFF, we reject your response on why you should not be recused. We still call strongly and submit that you must recuse yourself. What you've said does not really help this committee. If you recuse yourself and leave this committee to deal with this matter in the most fair manner, it will be beneficial for all of us, including all South Africans. And then, Chair, secondly, I personally did not hear what Honorable Mileham was saying. It's not clear what he says on his recusal. So can he please state his position on the recusal application against him so that it's for the record and the world knows? And also, he must, again, clarify his position on the fact that he has got conflict of interest. It's a known fact, Chair, that his wife is the one who tabled this motion before Parliament. from the DA. And he is now sitting in this committee. And we can't shy away from that. I mean, he's the husband, unless if they've divorced, we don't know. Now, the third one, Chair, is on Advocate Fatima. She started by saying that, talking about Advocate James, that she didn't just do the work for the DA. So can she also tell us which other political parties did he do the work for? Because all we know is that he did the work for the DA. At least DA is sitting in this committee. We're talking about the people that are in this committee. And we are saying the DA, and we're not going to shy away from that, Chair. It's said everywhere. It's an EFF motion. When the motion of expropriation of land without compensation in Parliament was debated, it was the EFF motion. This one is the motion of the DA. And we can't be told that we should not call it the motion of the DA's motion of Parliament. It is before Parliament, it was brought by the DA, and we're not going to shy away from that. So this motion of the DA, Chairperson, where the member of the DA is sitting in the same committee, and you as the chairperson of this committee, you go and source legal opinion on the advocate of the DA. How do you not see that that is conflict of interest? Why didn't you go to Advocate Ngokaitobi or any of the advocates that are used by the EFF? You know our advocates. You didn't do that. You went to the DA advocate. And for those reasons, Chair, we are saying there is clear conflict of interest. But not only that, the fact that, Chair, we still put it on record that we never mandated you to go and seek legal opinion. We debated here as the committee. And of course, I'm one of those who said, why don't you go seek a legal opinion? But it was never a resolution of this committee. So you went beyond your borders to go and seek legal opinion. While we reject it, Chair, we are not going to accept it. I thank you.
Thank you, Honorable Maute, for your contribution. I now recognize Honorable Paikizwe Ngosi.
Thank you, Chairperson. I'll just switch on just to show you that I'm here. May I switch the camera off? Thank you.
Yes, go ahead. Yes, go ahead.
No, Chair, I think there are three issues tabled before us. First, it's your response to the recusal application, and I deal with that in that order. Chair, I've read as you were responding to the application by the PP that you should recuse yourself. I think my conclusion is one, that it is a fair presentation by yourself, and because it is personal and directed to you, that you have provided adequate reasons for not accepting the recusal, and therefore accept your decision. In as far as Honorable Mileham is concerned, I think the same approach applies. I think I've listened to him. I've not read any document, but I've listened to him attentively, and that I am convinced that there is no conflict of interest, and that he should continue his membership of the committee and make a contribution. On the third issue, Chair, of the legal opinion, I'm satisfied that Parliament has gone on a public procurement process based on the transcripts and the law, including the Constitution. I think it's section 217, which calls for an open and unbiased procurement system, and satisfied that if that process, in fact, that process has been followed, and therefore what concerns us is that and that only. I do not see any bias in relation to the advocate chosen through an open process, and support this. Thank you, Chair.
Thank you, Honorable Paikizwe Ngosi. I now recognize Honorable Maneli.
Thank you, Honorable Chair. Greetings to honorable members of the platform. I request your permission, Chair, not to switch on the video as I'm in transit.
Go ahead.
Thank you, Chair. Chair, I want to firstly join those who accept the presentations that both yourself and Honorable Mileham would have made in response to the recusal application, and that we should accept and be able to proceed with the work of the committee. Of course, Chair, in relation to the legal opinion, as Honorable Ngola would have said, we did not open the meeting and close it previously. We were already making inputs similar to what has been presented today. But out of courtesy and ensuring that the processes can be defensible going into the future, there was acceptance on the calls for a legal opinion so as not to see you as just responding in order to stay in that position. If the chair would remember, there were sort of warnings to say if we proceed in that way without getting an independent legal opinion, we will set ourselves for legal problems in the future. We now have the legal opinion, Chair. So I'm raising this so that it's understood that the main item is whether we agree with the presentation that you've made. The legal opinion sets the legal basis in terms of us looking at that matter. And of course, I've not heard, even in the objection to the legal opinion given, that there may have been any wrong quotation of case laws to justify what has been put before us. That's not been the case. And therefore, I agree also that the legal opinion supports this view that with the facts you've presented before us, which we can attest to as members who have been regularly present in the meetings, except where we would need to apologize, that you have presented what we are all aware of. And this is the bar that has been set right in the beginning. And these assurances were such that even at the time of continuing under the protest, it has been the belief even from the PP side that the matters were being handled as they are expected to be handled. We're almost at the end in terms of the first phase of witnesses, Chair, under that guidance. I think we should accept that that is the case. And lastly, it's really that, Chair, we should at all times remember this. And now it's proven by legal opinion that indeed we may come from different political parties, and we cannot pretend that people may have not held views either side at a particular time on a matter. But we have conducted ourselves as members of parliament with an open mind. And that's why we even entertain some of the questions raised by members who may have been confirmed previously when we asked a question of whether the advocate holds a brief in terms of putting their apologies when they were not presented. And the advocate made it very clear that it's raised on the basis that some of them may be the clients of the advocate, he relates with them, and we've never seen that as any bias whatsoever in the way they interact with issues. And I want to suggest, Chair, that we proceed on the basis that there's not been that demonstration on your side, and that we must be able to proceed, Chair. So I'm sure you do get my separation of the issues, that it's about yourselves. We have accepted that. The legal opinion only serves as the basis to give the legal framework from which we can also lean on. Otherwise, we would have finalized the matter, Chair, respectfully, even on that day. But we respected this thing that it can't be just about numbers. We are now warned again about numbers. I hope at some point you can also make a ruling on this. The numbers are not an issue here, because those have already been dealt with in an election outcome in 2019. So there's no doubt about numbers, but we should allow space for us to engage freely as members of parliament, not to use anything to intimidate or preempt what a member would say or not say. I submit, Chair. Thank you.
Thank you, Honorable Maneli, for your contribution. I now recognize Honorable Nodada. Honorable Nodada.
Good afternoon, Chair. Chair, am I audible?
Yes, we can hear you.
Yes, thank you so much, Chair. Chair, I think I've been covered by the majority of the members, and appreciate the fact that when we did request this legal opinion to be sought, it has been done so. As I remember being part of that meeting of the committee. And I am not aware as a legislator that legal scholars belong to specific political parties. The last time I checked, it is the high courts of this country that admit legal scholars. And if they are advocates, they belong to a bar. But be that as it may, I want to support the notion that this legal opinion be taken on board by the committee as presented, because that's what we seek to be advised on as a committee, for us to determine the grounds in which were put towards you as a chairperson on the allegations of bias, as well as Honorable Mileham. And I want to support the notion that says, let's accept the legal opinion as presented to us, because it's thoroughly done so. And it stated everything in law, which as legislators, the makers of law, we should be able to understand. And in moving forward, Chair, to also accept the fact that you and Honorable Mileham have exercised your rights to not recuse yourself based on the facts that you've presented to this committee, and based on what we've read in the legal opinion, supports the statements that you've made here today. And without wasting any time, Chair, to ensure that the public protector is not prejudiced in any way, let's ensure that we process or proceed with a timetable of meetings to ensure that the proceedings take place without prejudicing the PP in terms of time taken to take her through this process to ensure that she gets justice, Chair. Thank you so much.
Thank you, Honorable Nodada. Honorable Hendricks, are you back? Honorable Hendricks. Honorable Suela. Honorable Suela.
Thank you,
Sorry,
Chairperson.
Honorable.
Thank you, Chair.
Yeah, I've been struggling with a device.
I'll come back to you, Honorable Hendricks. Honorable Suela, please proceed.
Thank you, Chairperson. Chair, let me welcome the presentations made. Let me welcome the presentation made by your good self and Honorable Mileham, as well as the independent legal. Chair, I don't want to go deeper, but just to indicate that the issue of the legal opinion was raised by our good selves into that particular meeting. Fortunately, I was there, so there is nothing wrong with that. And I want to support what has been presented up to so far. Because we are not legal gurus, we rely on their wisdom. Secondly, Chair, I haven't observed any biasness or unfairness in your conduct as the chair. Hence, I would like to support your presentation and your firmness that you are not moving an inch to move out from this committee. What we are expecting, Chair, is to allow the PP to be given an opportunity to come and respond to those issues which have been tabled by those witnesses. And secondly, Chair, we are not in a court. We are in a process of inquiry where fairness should prevail. So we must not deprive the PP her rights. We must allow her to come and present herself so that at the end of the day, we can be able to make a decision. For now, there is no outcome, according to my understanding. But to allow this process to unfold, let us stick to the rules. I don't see any reason of deferring this matter because it's not our matter. This matter belongs to you and Honorable Mylon. So we are accepting your presentation, both of you. So by so saying, we are saying, let's proceed with the inquiry. Thank you, Chair.
Thank you, Honorable Suella, for your contribution. Honorable Hendricks.
Thank you for your indulgence, Honorable Chair. And Honorable Chair, thank you for agreeing to the Al Jamaa position when we had a debate that you should not recuse yourself, as it is our view that you showed no bias and did your best endeavors to speed up this inquiry. And that's what we liked about you, and we didn't want you to recuse yourself. Having said that, let it be known that this was a DA motion, most probably captured from the EFF that was adopted. We also note that this motion had the support of the ANC, whether it was a DA motion or an EFF motion. We also know that about 60 MPs of the ANC, including ministers, abstained from this motion. That is why Al Jamaa, however, has a quarrel with the agenda. If you put the agenda to the committee, Al Jamaa would have objected to the adjective that a legal advisor is independent. There are different views whether he's independent or not, as we heard. So we would have been able to address that and not burden the committee with the many responses we had. So, however, the responses, like other honorable members have indicated, was certainly independent, professional in terms of the case law. And I doubted very much if anyone would challenge that. So, Honorable Chair, you went the extra mile to get an opinion to assist you make a personal decision. So that has got nothing to do with the committee. We don't have the right to tell you how to exercise your mind and make independent decisions, and the same with the DA representative. And what we have seen is that you have been very careful and maybe too careful. So Al Jamaa now calls on you to continue to speed up this whole process and keep the cost down. You say you are not a judge and that this is not a court. I ever have a problem that you are trying to act as a judge and you are giving the legal eagles all the rights that they have in a court, which I don't think you need to do. And you're also becoming a bit legalistic and trying, and which delays a resolution to this matter. No other matter like this have taken up so much time of honorable members who must now neglect, for example, their constituency work. Mr. Chairman, don't let constitutional court processes and leniency extend this hearing unnecessary. No one can force you to practice the hardcore court procedures you seem to be adopting to be accommodating. This committee is not a court. You are not a judge. We call on you to take up your position as chairman and give us leadership, because it cannot be that Parliament is spending so much money on a matter, and that this motion that was put forward by the DA or the EFF seems to be uncertainty now, is costing the taxpayers a lot of money. Motions mustn't cost so much money. And that's why, in our view, we make another call that this matter must be speeded up and come to a conclusion. And we ask all parties not to derail this committee so that we forever and forever have to deliberate on this matter. Thank you very much, Honorable Chair. And thank you very much for not recusing yourself. That's a personal decision which the nation will appreciate. Thank you.
Thank you, Honorable Hendricks. Your contributions are well noted and the issues you raise. And I recognize Honorable Majosi.
Thank you, Honorable Chairperson. Honorable Chair and Honorable members, good afternoon. With regards to the matter that is at hand, I would state that we had something similar to this before, that we are not being fair. As members of this committee, we were outspoken on how on the fairness that you had during the proceedings. And with this matter that you must recuse yourself, we don't see you, Chair, and then Honorable Mileham acted in any way that would warrant either of you guys or of you honorable members recusing yourself or being removed from this committee. And as the IFP's position is that both of you are not going to recuse yourself or either be removed from the committee, such that bringing such a process of recusal is undermining to the work of the committee, and also to honorable members that serve in this committee. We have read the legal opinion, and we agree. Paragraph 30 to 36 talks about the interest of the case, impartial and biased. 1441, it's about the Concord and CSA. So we agree that we have been very, very objective. You have been very, very fair in this committee. And the fact that if all of us in this committee, we came with the same mandate, that we want to see the process of the committee finishing, and after then, we'll then have an opinion, or we'll then put what we think as members of parliament, what we think should happen with the proceedings of the PP. But what really happened is that we came here with a subjective mind. We were not objective, and that on its own, then it doesn't give us a mandate or an idea of what is it that we should do. But as the IFP, our position is that you must stay as the chairperson, do not recuse yourself or be removed in the committee, and of Honorable MP Mileham as well, that he must stay in this committee as a full member of parliament and as a full member of this committee, and you must not recuse yourself. Thank you very much, Chair.
Thank you, Honorable Majosi, for your contribution. It's welcome and noted. Honorable Sukas, followed by Honorable Melda, and hopefully Honorable Glagode is available to speak.
Thank you, Chair. Chair, I'm not going to be long, because I think I've been covered substantially by every member that has spoken in support of you not recusing yourself, as well as the Honorable Mileham. Chair, you stated earlier the oversight function that we have as a committee of parliament. And in light of that, and also to hook on to what has been raised by Honorable Hendricks, I want to request a detailed report on the what the legal costs are to the people of South Africa. Because as our role as public representatives, first and foremost, is that of accountability and oversight. And I think in line with that, we need to have detail on what the costs are. Because as we know with the BRRR reports right now, every single cost has an impact on service delivery on the ground for our people. So in light of that, I would ask that we be provided with that. Thank you.
Thank you, Honorable Sukas. That's well noted. Honorable Mulder.
Yes, thank you, Honorable Chairperson. We find ourselves in a constitutional democracy, which means that the public protector, as well as our advocate, Mr. Mpofu, has rights. And that is correctly so, and they were completely within their rights to bring such an application because they felt it was necessary for yourself to recuse yourself as well as Mr. Mileham. But in a constitutional democracy, they are not the only ones with rights. The chairperson and Mr. Mileham and the committee also and Parliament also has rights. So the application was brought against yourself as the chairperson and against Mr. Mileham as an individual member of the committee. And it was correct then that both of you expressed yourselves in terms of your perception and your view, whether you should adhere to that application or not. Nobody else can decide on your behalf. It was your own interpretation and your decisions to do so. So the legal opinion in that regard, I see as a bonus because technically we did not need a legal opinion, but you went that far to get a legal opinion, and it was necessary looking back, because if you did not do so, I can assure you that some would have argued that your decision not to recuse yourself is not a rational decision, that you've not applied your mind. So the legal opinion, I think, was quite important to bring us to that point and to that position, and the same with Mr. Mileham. I'm a bit amazed at the arguments about the bias position, so-called bias position of the legal practitioner. I think it's quite fascinating to hear that argument, because I've never heard that people go into the background of legal people to see who they represented or not. If you want to go down that route, I think the advocate of the public protector, I think he appeared for the EFF on numerous occasions, and nobody said the EFF should withdraw or recuse themselves from these proceedings. So I think that it's a false argument. The law is the law, and I think the legal opinion quite clearly indicates what the position is. So, Chairperson, my view, and I'm of the opinion that neither yourself nor Mr. Mileham should recuse yourselves. I think you should proceed with the proceedings here. I haven't been involved in any procedures in Parliament over many years where someone has been given such leeway and the opportunity to be protected and to state her case than has been the position of the public protector. And we now come to the point in the proceedings where it's up to the public protector now to convince us of her innocence, and I think she should proceed with that. In conclusion, Chairperson, I would like to second the proposal made earlier in this discussion by Mr. Ngola, when he basically said that we take note of your position as well as that of Mr. Mileham, that you will not recuse yourselves, and that we accept the legal opinion from the advocate, and that we move on as soon as possible. Thank you.
Thank you, Honorable Mulder, also for your contribution. Well noted. I now recognize, as I go towards the end, I see the hand of Honorable Malema. Malema, are you still raising your hand? Honorable Malema, can you hear us? Okay. Honorable Zagode, are you back online? not sure whether they are. Or
No,
not.
Chair, I've lowered my hand.
Okay. Thank you, Honorable. Thank you, Honorable Malema. Honorable Dlagode, have you also lowered your hand?
Chair, we don't, I think she's disconnected. I don't see her on the platform.
Okay. That's fine. Yeah, thank you very much. That would have been the last member to speak on this. So I want to thank all the members that would have spoken and made their contributions on this matter in your diverse way of doing things. We can only embrace that and not have an issue with it. Firstly, Honorable Kola Ngola would have proposed that the meeting moves acceptance of the non-recusals by both Mr. Dyantyi and Mr. Mileham, and accepting the legal opinion. Honorable Melder has supported that. I also note a firm point being made by Honorable Mautwe that as the EFF, the non-recusal is not accepted, and that they want to have that recorded, that the chairperson and Mr. Mileham should recuse themselves. We will note that as part of the decision of this committee, because members in their contributions would have contributed in support in their various ways of us accepting this, but also firmly suggesting that let's move on with the work of the committee. And therefore, I think that's now the decision of the committee to accept the two non-recusals, having noted the legal opinion, and I've noted the firm minority view by Honorable Mautwe for that to be recorded. Honorable Holomisa would have raised options available to himself and others that they would wish to take up beyond this. That is also welcome. We are in no way going to be stand in the way of members exercising their various options. The next point is on the legal opinion. Listening to all the members, there would not have been much of contribution about the content of that legal opinion. I've noted the remarks about it, which then related as to how it originated and who authored and so on. But we're missing a contribution to robustly engage with the content of that legal opinion. I must also say up front that, as Honorable Melder would have indicated, the legal opinion is advisory in nature. This is an advice that was sought. It is not a decision. I took a decision on non-recusal. Honorable Mileham took a decision. Members of this committee are in support of the decisions we have taken, because you seek a legal opinion not to direct you. You seek it to help guide. I've said it before, it is a decision enabler. It's not in itself a decision. And I think it's that is going to help. And I think honorable members would have also raised the issue about the commentary on, so that we must desist regardless of how we feel about certain issues, so that the officials who work for Parliament and the National Assembly never find themselves to be part of a collateral damage in the manner we engage and articulate. And I really want to really ask members to refrain from such now and in future. And that's not asking them not to be robust, not to engage vigorously. We have to protect the professional body of this house. So that's really appreciated, colleagues. I think that Ms. Ibrahim, there would not be many issues that you need to respond to. So if you don't need to say anything, I would want to proceed. I think the issues have been attended to about how the appointment of anybody who provides legal services gets done as a transparent, open, competitive kind of process. And with our state attorney's office being involved in those processes. I think there's a big charge rising from number of members, Honorable Hendricks and all other members, to say the delays, firstly, are no longer going to have to be appreciated. We need to move with speed, because delaying this process is also not good to that office first, but as well as to the incumbent public protector. A sense of direction is needed, and that it is important that we allow the public protector very soon to state her case in the time that will be given to her. But before we can do that, we would need to be able to conclude the last witness. The last two witnesses, the PP team is supposed to conclude the cross-examination of Mr. Jani, and we're supposed to lead evidence of Mr. Van der Merwe. And it's the intention, therefore, that we don't delay that any further. I would have indicated that the intention is to make sure that balancing the work of the what I call annual report, others call it the triple what? BRRR. That's actually annual report. It's just a sexy thing to be, that's the annual report. We have to balance finding time, as all of you are now engaged in that process. And so with the committee secretariat, and I'm going to ask him, we're even looking at within this week, if there's a possibility for us to sit either on a Thursday, Friday, or even a Saturday, we'd want to share that with you. And once we've got the necessary approvals, we'll proceed in that way. So you, as you do your annual reports, be on standby to complete the task and continue with it that you have started. Mr. Ngoma, are you there to just come in now, and then I invite you to present what you need to present and indicate what members have called for, the restarting of the program.
Thank you, Chairperson. Good afternoon, and good afternoon to honorable members. Yes, Chairperson, as you have correctly indicated, we will have a look at the current parliamentary program, taking into consideration that a number of committees are currently busy with the budgetary review and recommendations reports, the BRR process that you spoke to. However, Thursday and Friday will be the possible days that we'll look at during the course of this week, but we'll conclude those discussions after this meeting. Chairperson, I just wanted to table the correspondence that the committee has received since the last time I done that. Chairperson, we've received, you would remember, honorable members, that in the previous presentations I had indicated that we had returned to a number of people of interest seeking information. So on the 26th of September, we had received a response on a letter that was sent to Mr. Siape and Ms. Keller requesting information. And that letter, Chair, was shared also during the course of the meeting with the members. So is the response from workmen's attorneys the response letter on behalf of Mrs. Lochenberg and Pillay. And Chairperson, the letter was following the request from the legal team of the PP that they reappear before the committee. However, they've both indicated not being available to appear for further cross-examination. The letter also has been shared with the members. Chair, we also had the same letter that went out to Ms. Paloi. She has also responded and indicated that due to her other commitments, she's not able to reappear before the committee. However, she's advised on the letter that if there are any questions that the legal team of the public protector wants to pose, they are welcome to do so in writing and should respond under oath. Chairperson, I had also indicated that we had returned to Mr. Ngobeni requesting information. We've received a response on the 30th of September. It is currently being studied in my office. And Chairperson, we also on the 1st of October, we received a letter from Public Interest South Africa complaining about the conduct of Advocate Mpofu during the committee meeting of the 13th, and also requesting that maybe you launch a complaint with certain legal bodies that regulate legal minds or legal people. Chair, we wrote back to Public Interest SA indicating that we cannot deal with their matter now because there was this recusal application before the committee. And Chair, also just to remind the committee that it had also taken resolved at its previous meeting that the conduct of Advocate Mpofu will be investigated. However, for the purposes of the letter to the public interest, it was specifically addressed to you. You responded to say that unfortunately you could not deal with that at the current stage. Chairperson, then on the 11th of October, we had received a letter from GG attorneys, Gadi Godrich attorneys, requesting also the recusal of the evidence lead, calling for the evidence, the recusal of evidence leader Advocate Bauer Senior Counsel. Chair, we have since sent that letter to Advocate Bauer, and we are hoping for a response very soon. Chairperson, on the 14th of October, even though the letter is dated the 12th of October, and this was upon request, Chairperson, that through the office of Mr. Holomisa, that they provide us with the letter that we're being that was being inquired about in the committee, but we had not received it. Eventually, on the 14th, we received the letter, Chair, also talking on the recusal of the evidence leader. And calling for her to recuse herself from the committee. Chair, that letter will be transferred to the legal to the evidence leader for a response as well. And also, Chair, just on that letter, if I can just request honourable members that when they write to the committee, they try at all times to address the communication to the committee secretary. And I'm almost certain that members, I'm actually 100% certain that members all have my email address, because we had to make numerous requests for the letters of the 11th and the 14th of October, Chair, as they were not sent through my office. Chair, that is the correspondence before this committee, which has been shared with members and will also be uploaded on the Uvimba, which all members have access to. Thank you very much, Chairperson.
Thank you, Committee Secretary Temugo Singoma, for placing that important information in and out correspondence. I see the hand before I proceed of Honorable Mauta.
Yeah, no, thank you, Chair. I wanted to come in before the Secretary of the Committee speak, but I did not want to interrupt. Chair, just two things on my side. Chair, I raised the issue of costs way back in July, and you said you were going to come back to us. You still haven't come back to the committee to tell us how much are we spending per day on average and how much have we spent so far. So I just respectfully would like to remind the chair to say, please, let us know. But secondly, Chair, it's just a point of clarity. What's the role of the PP in today's or her legal team in today's proceedings? You spoke in response to your recusal. Mr. Mileham spoke, even though we didn't hear what he was saying, but he spoke. And then the legal opinion was also presented to us. And we, as the member of the committee, also had an input, but you have not indicated when is the PP or her attorneys coming to respond. Because remember, this is their application. We're just responding to it. So if you can give that clarity, Chair, I'll appreciate. Thank you.
Thank you, Honorable Motor, for those 2 points. I think the first one, myself having a bit of a good memory, I want to agree with you that you did raise that matter before around the issue of the costs. So I can only say that we're going to take up the matter. So I'm just confirming that your recollection in that regard is correct, first. Secondly, on the second point, today's meeting is a committee meeting. That's why you would not have the evidence leaders as well as the public protector. But based on this, we are going to communicate immediately with the public protector about the outcome of the response to the recusal formally. So they will be able to join us in the next meeting, which will be the inquiry session. And I hope therefore that kind of clarifies the points you have raised. Based on this correspondence, we will come back to the members either in our next meeting or maybe before that, because for now, as Thembinkosi has indicated, we are going to await for the response of Advocate Bauer to respond to the issues. I would have written her a letter to clarify both letters from Godrich, Gadi attorneys, and as well as Honorable Olomisa's letter. You will be informed of that particular process as members of this committee. Just wanted to clarify that. Thembinkosi.
Thank you very much. Just one important letter that I omitted, Chair, which I will share with the members. The response by the evidence leaders on the letter from the EFF Chief Whip relating to their inappropriate conduct. So we also do have that letter, Chair. I just felt that it's important that I mentioned it, that I omitted it previously. Sorry, Chair. And the necessary action will be taken, Chair, of processing the letter. Thank you very much.
Okay. Thank you, Thembinkosi. Honorable members, that is the last matters, the business of today's meeting that would have attended. Certainly, I think as a chair, there are certain things that we're going to have to expedite and speed up and keep you in touch with all of those. There being no other matter,
I'm so sorry to do this to you, Chair. The very last one. Are you saying we're continuing on Thursday? And if that is the case, are we continuing still with Advocate Bauer's issue not resolved? Or are you saying that you're going to get the response of Advocate Bauer prior Thursday, so that when we continue on Thursday, at least there's no pending issue from her side in terms of her own recusal, her conduct? Thank you, Chair.
Thank you, Honorable Mileham. We, as the Committee Secretary would have indicated, immediately after this meeting, we're going to confirm the exact date of our meeting, whether it's Thursday, Friday, or Saturday, and members will be informed. And it is our intention to attend to Advocate Bauer's matter before such a meeting. So I'm hoping that you will hear before that meeting from us. I hope that helps, Honorable Maute and other members. With that, honorable members, I can see you were missing this meeting, so you don't want to It is Honorable Gondwe.
Thank you, Chair. It's just a question of clarity. I just wanted to get an indication of when exactly we're going to hear about, subsequent meetings. Because I'm a bit worried that sometimes we hear at the last minute and
Yeah.
we've made plans for,
That's fine. As you leave here now, and we adjourn, you go for lunch, myself and Tembegos will be at work. So we're hoping at least by later tonight, first thing tomorrow morning to indicate that. Thank you. It like for my demands of Khani. Honorable Hendricks.
I'm sorry to do this to you, Mr. Chairman. Mr. Chairman, I heard that the Secretary has taken a unilateral decision to refer the matter to Mrs. Bauer. I was just wondering why he didn't refer the letter to the Speaker, because it was the Speaker who asked the State Attorney to appoint an evidence leader. Why must this committee be burdened with these things? So many things are being done to derail us. I don't know why people are thinking of ingenious methods just to derail us. That is not our concern. That's a matter between the Speaker has appointed her with the State Attorney. They mustn't burden this committee with these things. So why didn't the committee secretary refer it to the Speaker to deal with? We've got enough work on our plate. Thank you very much.
Okay, no, thank you, Honorable Hendricks. For now, I'm going to ask that we accept all the bona fides of everybody here, including those that are raising the critical issues either about myself or about the evidence leaders. The committee secretary would have been instructed by myself as a chair how to process the matters. It is in good hands. You would know that this is a committee matter, so the Speaker has an arm's length to such an issue. It's committee operations. She can't get involved. We'll report to her at the end, but rest assured, the matter is well handled. Thank you very much. Thank you, members. There will not be a stop of hands until I adjourn the meeting. The meeting is adjourned. Thank you.
Long live the chair.
Long live Chairperson. Thank you, Chair.